We are here for day 3 of the evidence you're hearing on revenue requirement for 2 Public Service Commission dockets, 2035-4 and 1835-36, Rocky Mountain Power's general rate case and depreciation case. And at this point, we were ready for Rocky Mountain Power's cross-examination of Dr. Joni Zenger. So we'll move forward to that point.
Okay, can you hear me okay? This is Lauren for the company. I've switched seats so that I was told that when I was speaking from my own computer, my face didn't show up on the YouTube stream. So even though it doesn't have my name there.
I am not seeing Dr. Zenger having joined us. I should have checked that before we moved forward. I don't see her on the video conference list, participant list. Mr. Jetter, do you know if she is having technology issues this morning?
Well, not that I'm aware of, but let me follow up and see. We've been in communication this morning, and so I think she should be joining shortly, but I'm going to, oh, there she is. Morning, Joni.
Dr. Zenger, can you hear us?
Yes, good morning.
Okay, thank you. You're still under oath from yesterday, so we'll move forward with Ms. Sherman's cross-examination questions of you.
Okay, thank you.
Okay. Good morning, Dr. Zenger. How are you this morning?
Good, thank you.
Okay, so I wanted to start with just a few points of clarification from your rebuttal testimony. In your direct testimony, you had raised a question as to whether the Prior Mountain project was addressed in the company's 2019 IRP. And then I see in your rebuttal testimony, you've addressed that on page 7 of your rebuttal. And so I just wanted to make sure that I understand your testimony. Are you clarifying in your rebuttal testimony that you now recognize that the company did identify a need for new wind capacity in the portfolio development cases in the 2019 IRP?
No, to clarify my position, it was, as Rick mentioned, there was a bullet point in the May meeting. Is that static coming from I hope it's not from my line, but did anyone hear the static? Okay.
I am not hearing the static on my end.
Okay, great. So, yeah, so I was clarifying that it was mentioned in a bullet point, and then I explained how, it wasn't something that was vetted through the IRP, like thoroughly, and most people didn't even know it was in the IRP, even the Oregon Commission staff and your own policy witness in Oregon didn't even, I put statements there that Mr. Wilding didn't even know it was in the IRP. But when I did do the Google search, I saw it was mentioned in their IRP. So, no, the first part of your question, yes, I agree with. The second part, no.
Okay, and so in your rebuttal testimony, you discussed the stakeholder meeting that you attended in May 2019, is that correct?
Yes.
Okay, and then you described Mr. Link's testimony where he explained that the company communicated at that meeting that there was limited opportunity to acquire wind resources that would not require significant incremental transmission upgrades, and that could still come online by the end of 2020 to qualify for the production tax credit, and that the company might procure that resource outside of the competitive solicitation process. Do you see that part of your rebuttal testimony on page 7?
Yes.
Okay, and then you are agreeing with Mr. Link's characterization of what was communicated at that meeting, is that right?
Yes.
Okay, thank you. And the snapshot of the PowerPoint presentation that you've included at the bottom of page 7 of your rebuttal testimony You've highlighted that first bullet point that says in the near term, all cases include 240 megawatts of new Wyoming wind. And the cases that that's referring to are the portfolio development cases that were being discussed in the IRP planning meeting. Is that correct?
Those I can't testify to. I saw the bullet point. It said Wyoming wind.
Okay, so but you did this slide in your testimony, and it discusses the cases, and these are, you recall discussing portfolio development cases, and that's what's shown on this slide?
Not until after Mr. Link pointed it out here. I do not recall that part.
Okay. You recall generally participating in the 2019 IRP planning process and discussing the capacity needs that the company's portfolio needed to fill?
Yes.
Okay. And you would agree, wouldn't you, that the company acknowledged throughout the IRP planning process that its system had a capacity deficiency that it would need to fill with resources?
Yes, every IRP basically does.
Okay. And do you recall that the IRP developed a preferred portfolio to meet those deficiencies, the capacity deficiencies?
Yes, but I was not aware of, at least to my knowledge, that the company had like hardwired those resources in every portfolio. I wasn't aware of it, and I don't think most IRP people were, including Witness in Oregon. That part we didn't, we did not know that these were hardwired into every portfolio.
What, you didn't understand that what was hardwired in? I'm not following.
240 megawatts of Wyoming wind.
Well, by the time the company issued the 2019 IRP, it had already acquired that, and it was identified as a utility-owned resource in the IRP, right? That's what you have you show on page 9 of your rebuttal testimony?
That's what I found out later when I was preparing my testimony.
Okay, but you would acknowledge, though, that the company had a deficit and a capacity need, even despite filling that 240 megawatt capacity with plugging Prior Mountain into that capacity, right?
Yes.
Okay. I want to shift a little bit to talk about production tax credits. You would agree with me generally that production tax credits are beneficial to the company's customers?
Mm-hmm. Yes.
Okay, and you agree also as a general proposition that the production tax credits under the Internal Revenue Code phase out?
You cut out a little bit there, but I think you said will phase out.
Correct.
Yes. Yes.
Okay. And you understand generally that in order to qualify for the 100% of the production tax credits, a project needed to have started construction before January 1st, 2017? There's a start of construction requirement, in other words?
Yes, in order to get the full 100%.
Correct. And you understand that the company intended to use the safe harbor equipment in order to satisfy that start of construction requirement for this Prior Mountain project?
Yes, I didn't understand until Mr. Van Engelenhoven testified, and I don't think that most people understood this, that this the BHER resources you could take a piece of that and set it aside, and that would apply for a whole entire project. I think that's something about the asymmetry of information in these general rate cases or resource decisions, because we just thought that every piece had to be meet the standard. So we didn't know you could set aside a bookend and that would be set aside for that project like that.
Okay. Sitting here today, you understand that though?
Yes, I do.
Okay. And you also understand that there's a continuous efforts requirement, that a project needs to have continuous efforts towards completion in order to qualify for the production tax credit?
Yes.
Okay. And then you understand that there's a continuity safe harbor where if a project is completed, at least in the 2019, the project, as of the 2019 timeframe, the project needed to be completed by the end of 2020 to qualify for the full production tax credit.
Yes.
Okay. And you testified, I think, that you acknowledged that the company identified the opportunity to acquire the Pryor Mountain project in October 2018. Is that correct?
Yes.
Okay.
If I may, I need to explain some clarification on that, if you have a minute, because it goes towards my whole summary statement and everything. When the company said that they had started the process in June of 2018, I took that to mean that that's when the company made the decision to pursue this resource. So it wasn't until last night when I played Mr. Van Engelenhoven's testimony on the stand that when he explained that it wasn't until the June appropriation request that point was the point of the resource decision from the company. So I just want to point that out because that changes a lot of assumptions in my testimonies. You know, if I had known that at June 21st, when all of these other things were put in place, that would have changed my conclusion because I understood it to mean that this was happening in 2018. And that's why I thought, well, this is impossible to get all this done in time. So I hope that helps a little.
Okay, yeah, and we can get into that a little bit more as we through the points that you made in your testimony. But thank you for clarifying that. Okay, so we can agree, can't we, that the ability to acquire, develop this project in time for 100% PTC eligibility was a time-limited opportunity, correct?
Correct.
Okay. And there can be instances where a utility acts prudently to take advantage of time-limited opportunities, right?
We've seen that in the 39 and 40 docket.
Right. Okay. And you would agree with me that under the Utah statute, the Energy Resource Procurement Act, there's not a requirement for a solicitation process for a project like Pryor Mountain that's under 300 megawatt nameplate capacity, right?
Right.
Okay. So let's talk now about some of the points that you raised in your summary yesterday and in your pre-filed testimony. You had a point that the initial purchase price, and I wanted to clarify that you have a figure and it's designated as confidential, so we'll try to talk about it without using the actual number in your testimony. But it's on, let's see here, line 222 of your SIR rebuttal, which is page 11.
Oh, my SIR rebuttal? Okay, so I apologize. I only have my laptop, so I'm going to have to jump to that document. And so if my screen cuts out, that's because I've got to jump to that real quickly, and I have it here.
No problem. I've got two laptops going on at the same time, so I think we're both.
I wish I did have two, but something happened to one yesterday. So you're talking about page what page of my SIR rebuttal?
Page 11. And do you see there where it says that the company purchased a partially developed wind project from Energy Renewables, and then you cite a dollar amount there, and you say that
Yes,
was
yes, I'm there.
okay. And you had some authority that you cited for that figure. I believe my colleague, Mr. Sabin, has emailed out 2 exhibits. It is the documents that you cited in your SIR rebuttal, which was DPU 6.1-10 and DPU 18.2. I'm wondering if you have those in front of you or if your counsel has shared those with you. They're confidential, so I think we only distributed them to counsel.
I have those I can pull up without looking for his email.
Okay.
Which one do you want me to look at first?
DPU 6.1-10, I believe, is where you obtained this figure from. Is that the, which we have marked as Rocky Mountain Power Cross Exhibit 10?
Okay, 1 moment.
Well, that's following along here. And this is the APR to authorize funding and construction for the Prior Mountain Wind Project.
Okay, just bear with me here. I'm almost there. I just had that pulled up this morning, so hang on. Okay, I have 6.1-10.
Okay, and that is the Prairie Mountain Wind Project authorization, the APR document, in other words, a request for approval of the appropriation request for the project.
Yeah, this is the proposal dated 6/21/19.
Correct. And is it fair to say, I noticed you cited this document throughout your SIR rebuttal. Is this primarily what you relied upon in performing your assessment of whether you think the project is prudent or reasonable?
It's part of it because mainly because this is all I had until DPU 18, set 18. I asked you guys to give me everything, all the investment appraisal documents, all the APRs, and I did not get those much later in the case. And so some of these are in DPU set 18, but this is certainly one of them.
Okay, and the other exhibit that we marked as Rocky Mountain Power Cross 11 was the investment appraisal document that produced as DPU 18.2. Do you have that, or have your counsel sent that one to you?
Okay.
And again, these are both confidential, so I think we can talk about them generally without disclosing any of the actual figures that are in the document.
Moment. $18.2, you say?
Correct. That was what was cited in your SIR rebuttal and what we marked as the cross exhibit 11.
Oh, okay, hang on. I have to pull up the attachment that goes with it. Okay, on 18.2, I have 1, 2, 3, 4. I have 8 documents on 18.2.
So I think what you had cited in your testimony was the investment appraisal for Fire Mountain. that.
Okay,
Uh,
that's the 2015 to 2020 document.
correct.
Okay, yes, I have that now, and I have the other I can switch to.
Okay, so is your testimony that these are the two documents that you primarily relied upon in assessing the reasonableness of the Prior Mountain project?
Yes. And again, my assessment was based on the assumption that the company's decision to pursue this was, back when in August of 2000, yes, it was.
Sorry, you cut out there for a second when you said.
I was just saying, and my testimony to rebuttal and summary statement yesterday was based on the understanding that the decision point, if you want to call it, for which the company decided to pursue the project was not here at the APR of June 21st. That changes things quite a bit. I thought it was a year prior to that.
Okay, and you heard Mr. Van Engelenhoven testify that from his perspective, the project was approved at the company level once the APR that he submitted was approved, and that's what we're looking at as Cross Exhibit 10. Is that your understanding?
My understanding is this document is the document that authorizes that. This is basically the point in time when the company made the decision to go forward with this project. It wasn't the other APR, which has a higher number than this one, but it was this June 21st one.
Okay, and the EU 18.2, this is an investment appraisal. I just want to make sure we're clear on what this document is. If you look at the executive summary, again, without disclosing confidential information, it says that this is an appraisal to authorize a capital expenditure to interconnect 240 megawatts of new wind generation to one of PacifiCorp's transmission lines. So you understand that this DPU 18.2 document relates to just the interconnection aspect of the Prior Mountain Wind project? Yes.
Like I say, I went through each of those documents in set 18.
Okay. So going back to where I think we started with this, we were talking about your testimony about the initial purchase price for the project. And I believe the figure that you cite in your testimony comes from page 3 of the APR document, which is DPU 6.1-10. Is that correct?
The figure in my direct testimony?
In your sir rebuttal testimony?
In my sir rebuttal?
You have a figure on line 222 of your sir rebuttal that seems to match the figure on page 3 of the APR document. So I'm just trying to confirm that that's where you got that figure from.
Okay, just bear with me. I'm not used to having just one laptop screen, so a little longer. Okay, so the one in paragraph 4 or the one in paragraph 7? I have two numbers.
Paragraph 4, which you say is the initial purchase, right?
Yeah, yes. The 2019 expenditure.
Okay, and so you see where that is in the APR documents under CapEx budget status?
Yes. Mhm.
Okay, and I want to make sure we are clear on this point because it seems that the CapEx budget status and the amount that's listed there, it says that that's the amount required in 2019. And if you look at the chart there, you can see that's the entire capital expenditure budget for 2019, right?
Right.
Okay, and in your testimony, you said that that was the initial purchase. So that's not correct in your testimony, right? That figure that you cite is the entire 2019 budget, not the initial purchase price.
Correct. I learned that, yes, after Mr. Van Engel and Hoven testified.
Okay, thank you. And I think you also cite that same figure on line 315 of your rebuttal. You cite that figure as the amount to purchase the project from Energy. That's incorrect as well on line 315 of your rebuttal.
Yeah, like I say, I write the company's initial decision to spend this. That's when I understood the company's decision to pursue this project was at that time and for that amount.
Okay, so we're clear now that that amount was the entire 2019 expenditure, not the initial purchase price. Do you know what the initial, without disclosing a figure, do you know what the initial purchase price was?
Yes.
Okay, it was significantly less than what's cited in your rebuttal, right?
On which line?
That we've been looking at on line 315 and on 222.
So, when you say it's less, are you referring to?
I'm referring to the price that the company paid to purchase the project and the development rights from Energy.
Okay, yes.
Sorry.
Okay, so that number would have been less, yes.
Okay, and you can see from the first page of the APR document that we've been looking at, DPU 6.1-10, in the first paragraph there, it talks about the preliminary development funding for the project was originally approved with APR 20007-004 dated May 10th, 2019. Do you see that?
Let's see. You're not talking about the Bowler Flats APR, right?
No.
Okay, hang on.
I'm talking about the APR that approved the funding for the original purchase of the project.
The one we just talked about in 6.10 or 6.1.
So I'm looking at 6.1, and it mentions that there was a prior APR that approved development funding for the project.
Okay.
Preliminary development funding.
I recall that,
Okay. And so, and it says this APR, along with costs incurred to date, are included in the amount requested in this APR and represent total funding for the project. Do you see that?
Is this on the first page?
Yes.
Okay, and this is the June 21st one, right?
Right.
And can you repeat the sentence from here?
Sure, I'm just looking under decisions required, that first section on the first page.
Oh, okay. I'm on that paragraph.
And towards the end of that paragraph, it says preliminary development funding for this project was originally approved with APR 2007-004 dated May 10th, 2019. That authorization, along with costs incurred to date, are included in the amount requested in this APR and represent total funding for this project.
Yes, I do see that.
So you'd agree that the initial acquisition of the project went through one APR process, and then the project went through APR approval again in June 2019, once the company had developed total funding and capital expenditure budget for the project, right?
Yes.
Okay. And you mentioned in your summary and your testimony that the 2019 spend was unbudgeted.
Yes.
Now, given that the opportunity to acquire the project arose the end of 2018, it wouldn't be surprising that that wouldn't be reflected in the 2019 budget, which would have already been prepared by that time, right?
Let's see, you sign off on, usually the business plan is signed off on in December for the 10-year plan. So.
Okay, and we just established that the capital expenditure budget for the project would have been developed between that time of the first APR approval and the second APR approval. So it makes sense that there was no line item for this project in the 2019 budget, right?
Because we're talking about a difference in date of June 21st and I'm sorry, I'm really handicapped by having to jump one at a time. Yeah, from June 21st to the IAD that is a 5-year. It doesn't have a date. It's just a 5-year. It says 2015 to 2020.
Okay,
So
well,
from that,
I'm talking about your point that it wasn't in the 2019 budget, which would have been prepared presumably prior to 2019 to be a 2019 budget, right?
right.
And so is it your position that a utility can never take advantage of an opportunity not expressly mentioned in a budget?
No.
Okay. And you also mentioned in your summary, I believe yesterday, that the APR that we've been looking at wasn't signed by the appropriate authorizer. Do you recall mentioning that yesterday in your summary?
I do.
Okay. Was that mentioned anywhere in your pre-file testimony?
Let's see. It wouldn't have been in my direct testimony because at that time I explained that I was still sorting through all of these data requests. So I know it wouldn't have been in there, but I know I referred to the point that I was going to continue to investigate all of these other documents.
Is it in your rebuttal testimony?
Let me check really quickly. Yeah, it is not spelled out. It's not called out specifically in my rebuttal.
Okay, but so the point that you made in your summary was that, help me understand, is it that there's not a physical signature on this APR document?
Yes, I've reviewed these before in the past in several, in fact, wind projects. And it's been the company's position once the approval document's prepared, that the authorizing person signs off on it.
Okay, but you don't, okay, are you saying that you don't think, because you would expect to see a physical wet ink signature on this document, and that would lead you, that's what's leading you to believe that it wasn't signed off on by this company's CEO?
Well, yeah, it made me question it, yes.
Okay, but I mean, you don't think that this project would have gone forward without obtaining the APR approval, right?
No, I wouldn't have thought so.
I mean, it doesn't seem like it would be possible to have the funding approved without the necessary authorization, right?
Yeah, I wouldn't have thought so. So,
and to be clear, there's no line here for a signature, so
there's not a line on that. That's why I found that interesting.
Okay, but we can assume that there are some maybe other electronic means by which the CEO signs off on this or approves, right?
I'd like to know how you handle that so that I will know for future. If if you've eliminated having the person sign it, or yeah,
I'm sure.
So like I say, I'm coming from the outside. I don't have the information you have, so I just can go on what's presented.
Sorry, if I can interrupt for just a second. Ladies, if you could please wait for the other person to finish so I can make sure that I get everything that's said. When you're both talking, there's always one of you that's muted on my end, so I only hear one person.
Sure, thank you for that reminder.
Okay.
So it's a little bit different in this format than when you're live. The audio is a little more challenging, so I will commit to do better on that on my part. So let's just make sure we're clear on the APR document just generally that we've been looking at since you relied upon it. Your understanding is that the APR document is a report to allow management to review the scope of the project, review the risks associated with the project and the risk mitigation plan and the potential benefits of the project, right?
Correct.
Okay. And as you mentioned, it is prepared for the CEO's review and approval, right?
This one was.
Okay. So this document is reflective of careful planning for the project, isn't it?
Yes.
Okay.
I mean, we would hope it is, yeah.
Right. Another thing that you mentioned, I'm going to switch gears a little bit, but we may come back to this document. One thing that you mentioned in your summary was that the company is seeking, I think you called it an Eagle permit. Do you recall mentioning that yesterday? Yeah,
the U.S. Fish and Game. I can't think of the exact organization, but Mr. Van Engelenhoven, that was his first Q&A and his rebuttal testimony about that. U.S. Fish and Wildlife Department, I believe it's called.
Okay. And so did you mean to suggest in your summary that something about that project, that permit is going to create some type of delay in the project?
It made me question it, because what other reason would the company, have the opening Q&A for Mr. Van Engelenhoven on this topic? And plus, in reading those investment appraisal documents and the DPU set 18 that you sent me, it was mentioned. It was mentioned in the Carbon County permit areas, or conditional permit areas, that the company had made a donation of $400 towards the birds that have been killed, or for avian purposes. So yeah, it made me it was something that it was apparent that needed to be resolved before you finalize the project.
Okay, so just so we're on the same page, I believe you're referring to what, an Eagle incidental take permit from the U.S. Fish and Wildlife Services, is that right?
Yes.
Okay. And do you understand that permit is not required by U.S. Fish and Wildlife Services, or any federal agency does not require that permit be in place in order for the Pryor Mountain Wind Project to be placed in service?
No, I'm not aware of that.
Okay. Do you understand that the company is seeking that permit as essentially as it's listed in the APR document, basically a risk mitigation strategy?
Again, it was listed in the table, in the APR documents of things the company needed to do, major development and permitting, and what the status of them were. So I interpreted that to mean that it was something that needed to be acquired or achieved or waived by the company or the organization.
Okay, I believe you're referring to page 8 of the APR documents in that table at the top of that page. Is that correct?
1, 2, 3, like four rows down. Is that what you're looking at?
I'm looking at the second row from the bottom where it says Eagle or Protected Species Take Permit.
But that is what I was referring to.
Okay, and it says there in that table that if the permit is determined necessary by the company, it could be pursued post-closing. Is that correct?
I'm still looking for it, to be honest with you. Can you repeat what it says in there again?
Sure, and to be clear, I'm on page 8 of the APR document. It's the second row from the bottom on the table on that page, referring to the Eagle or Protected Species Take Permit, and it says, if determined necessary by the company, pursue post-closing. Is that right?
I recall reading that, so I can't jump to that exact table.
Okay, I don't want to belabor the point. We can move on.
Yeah. Oh, no, I actually do have it now.
Okay.
And what page did you say? I have it in front of me now. What page did you say that was?
8.
See, I think that's part of the problem, is because this 621 document, they're all labeled they're page 1 out of 16, but that was found on page 9. So there's like 4 page 9s, so it's a little confusing. But I found.
Sorry, I didn't mean to interrupt. We might be looking at a different document, so I don't know if it'd be helpful for your council to send you the one that's been marked so we're all looking at the same version. It might be helpful. But did you see the point that on the table that I just read?
I did see that one.
Okay.
If determined necessary by the company, pursue post-closing. So,
Okay. I'm going to move on to a slightly different topic. Something similar to this that you mentioned in your summary was that there were impact fees that must be paid to Carbon County. That was mentioned in your summary yesterday, right?
right.
And is that in your pre-file testimony anywhere?
I believe it is, but I'm looking for the documents from my attorney. Okay, here, cross documents. This will make it easier that I have the right documents pulled up. Okay, let me see if that was in my testimony. So it most likely was not in my direct, because my direct was the initial evaluation stating that I would be going through these other documents with the fine tooth comb. So, so let me check my sure bill. I didn't specifically list that. I didn't specifically list that, but you know, I said these are some of the facts that I feel are relevant in this proceeding right now. Yeah, and that one's not called out.
Okay, so the impact fee that you mentioned in your summary, I believe that was pursuant to well, at least you said, I think it was pursuant to the conditional use permit from the county. Is that right?
Right.
Okay. Have you reviewed that permit?
I mean, I reviewed it at one point from Carbon County to determine that it was required.
Okay, and it was obtained. The permit's been obtained, right?
Excuse me, the permit what?
The permit has been obtained, correct?
I don't know if the whole thing has been paid. It mentioned that $4 million of it had been paid, and there was another $2 million required to be paid. So I don't know the dates when you guys paid that.
Okay, so was the point in your summary yesterday that the entire impact fee has yet to be paid? Is that the point you were trying to make?
Well, I was trying to make 2 points. One is that impact fee, I don't know if that was grouped along with some of the other costs, like in that APR that we pulled up this morning for the lower number.
Mm-hmm.
If it was grouped into that, or if it was just an incidental cost that you know has not been doesn't have a line item for. That was the primary point of bringing it up. I mean,
Okay.
And whether it was whether you paid the $4 million, the full $6 million, I think was secondary. The point was that there are these costs that would be line items, and I don't know if you paid them as a pre-development, right, or if they remain to be added to the project.
Okay. Well, if you reviewed the CUP, you might have seen that it requires payment of impact fees in installments. Does that ring a bell?
What I recall is that you had up to 3 years to pay it is what stands out in my mind. Is that correct?
Well, there's nothing unusual about the fact that one installment on the total impact fee is what has been paid to date, right?
No, I just don't know, where it would have been accounted for and if.
And the APR document that we've been looking at, it lists permits that would be required for the project starting on page 7, and it specifically lists the conditional use permit, right?
Of the investment appraisal document?
No, the APR document. I apologize if I misspoke.
A moment again. Not the Bowler Flats one, but the June, not the May one, but the June APR. Is that
Correct.
the one you're referring?
Yep, what we've marked as cross exhibit 10.
Okay, I have the June 21 pulled up again. And what page?
Starting on page 7 is where I see the permits listed.
Again, I really apologize that I don't have my second screen. I could just keep this up and be looking at it. So
No worries, we're all just doing the best we can here.
yeah. Okay. Transfer to the company upon closing in May. Currently being amended by the county. That's what it says.
Great. So you see that the conditional use permit was identified as a permit that would be required, and it was planned and budgeted for under this APR document, right?
I just see on page 7, it says it was transferred to the company upon closing in May 2019, currently being amended by the county. So I don't know if there's another place in here that it says it was planned and budgeted for, but that's what's listed here on page 7.
Okay, well, the APR document is a planning and budgeting document, right? And the CUP is listed in here, so it's fair to say that this was planned for, right?
Yes.
Okay, I'm going to shift topics again and talk about the WTG equipment or the wind turbine equipment. You made a few assertions about that equipment in your summary and in your rebuttal that I'd like to ask you about. And you raised a couple of different points with respect to the wind turbine equipment. One of the points I think you made was that the company had limited time to secure the equipment, the turbines, get them to the job site, and then erect them in order to qualify for the full production tax credits. Do you recall that
Yes.
line of your testimony? Okay. In fact, that's what made this opportunity a time-limited opportunity, right? That there was that pending expiration of the PTCs, right?
Yes.
Okay, and did you hear Mr. Van Engelenhoven testify both at the hearing and in his written testimony as to how the company formulated a plan to address the logistics and the market constraints associated with that timing issue?
Yes, you're talking the COVID, the adjustments because of COVID?
No, I'm talking about the concern that you raised about between the time that the company acquired the project and the time to get the project in service in order to qualify for the PTCs, even setting aside COVID. Mr. Van Engelenhoven explained that the company developed a plan to address that timing and supply issue that you raised a concern with. Do you recall his testimony point?
I do recall him talking about I don't know if the word's commissioning, because, but doing in groups, in circuits, like, 3 different circuits, Rose.
Okay, so I think we're talking about 2 different things. I'm talking about the plan to acquire the equipment and get it to the job site. And it sounded like you were just talking about bringing the circuits in service. So I might just pull up Mr. Van Engelenhoven's testimony so we can
Okay.
get on the same page here. Hold on, I've got this 2-screen situation going on. Let me see if I can share my screen from my other laptop. 1 second. Okay, are you able to see Mr. Van Engelen's testimony here on the screen?
Yeah, just give me 1 minute, because I'm trying to pull up my summary statement as well, so I have that. Just 1 minute.
Okay, I have to direct you to starting on line 132 of his rebuttal, where he said, Pacific Corp secured the benefits of the project for customers by acquiring the components from BHER, which I think we understand is the Berkshire Hathaway entity, and avoided equipment supply limitations, construction issues, and price volatility. And you see that? And then I would also refer you to line 1.
Okay, I'm sorry. I have it pulled up now. I really am juggling a lot of documents. So, will you just repeat that line number you want me to look at?
I was looking at line 132, which I've highlighted on the screen here, if that's easier for you.
Okay, yes.
And then I would also direct you to line 141. The Pacific Corp had an opportunity to acquire components that were already manufactured and in storage from Berkshire Hathaway at cost, which was the competitive market price at their time of purchase in 2016. You recall that testimony, Van Engelenhoven?
Yes, thank you for pulling that up.
Problem. So you mentioned, I think, in your testimony and in your summary that it was a risk that the company would not be able to get the turbines to the job site. Do you think, in light of Mr. Van Engelenhoven's testimony, that the company developed an appropriate plan to be able to secure that WTG equipment and deliver it to the site?
Yes, especially when you mentioned yesterday that they're already manufactured and they're being stored in Colorado, which is just a couple of days drive from there. Yes.
Okay. And this was an issue that the company identified from the outset in its APR document, and it formulated a plan to address the concern about obtaining the WTG equipment, right?
Yes.
Okay, and it's true, isn't it, that the company was in fact able to secure all of the turbines that it needed for the project, right?
Right. Because I think another point of misunderstanding, that when the company talks about the WTG safe harbor equipment, I think probably Mr. Hyatt as well as I, we're thinking that's the wind turbine generator and the blade and the hub. So he pointed out that is the nacelles and the rotors and other parts, not the blades. So, yes.
Okay, but
Yeah.
my question is, sitting here today, what we know is that the company was able to secure and have delivered all 114 of the turbines, or at least I think Mr. Van Engelen-Koven's testimony was that they are being delivered this week or next week. So we don't have a concern sitting here today that the company wasn't able to secure the necessary number of turbines, right?
Right. I think that's been resolved.
Right. And that's even in the midst of the pandemic, which, as you mentioned, did create delays and disruptions to the supply chain, right?
Right.
Now, you also mentioned, and I would like some clarification on this point, that the company had to do a competitive bid for the follow-on turbines. Were you offering that as a criticism of the project in any way?
When I wrote that testimony and my summary on that, it was different than after Mr. Van Engelenhoven had explained this. It wasn't so much a criticism. It was that I was under the impression that they bought all the safe harbor equipment in 2016 at the market price then, which would have been a lot lower than it was in 2019. And it wasn't clear. What wasn't clear to me is that the company took all of the 73, the other parts that it had, and grouped them together into a Vestas turbine supply agreement that kind of encompassed everything. So, and then at a whole new pricing scheme that was negotiated. So, the company never submitted the Vestas turbine supply agreement. So I was not aware at the time that they had grouped these together, at the time of the market in 2019. So initially, yes, to answer your question, yes, I think that could have been a criticism, thinking that, oh, they're out on the market here at the very last minute and they're going to be paying premium top prices to get the rest of this. But from his testimony, I can see that whatever parts that Vestas had and you guys had, it was all negotiated into one turbine supply agreement.
Okay, so does that address your concerns that you previously had?
Yes. I mean, I would have liked to see the turbine supply agreement. So, I still don't know, the price that you ended up paying for that, if that, was a good deal for ratepayers or not. But it does address the fact that you were able to get all 114 turbines and parts.
Okay. I want to address something else that you said in your summary and your rebuttal. You said that the company did not consider alternatives to the project. I'm curious what your support is for that assertion. Are you relying on something in the documents, the APR, or the investment appraisal?
Yes.
Can you point me to what you were relying upon?
Sure. If you bear with me.
Sure.
So it would have been in the APR in DPU 6.1-10, the project proposal and APR request.
Is there something specific in that document you could point me to that you might have found?
Yeah, I mean, I found that in several documents. It was repeated the same time. So this is with the project proposal in DPU 6.1.10 dated June 21st, 2018. On paragraph 8, it says the Prairie Mountain project includes, oh wait, that was the alternatives. Yeah, that was the contingency. Okay, the alternatives should be in the same document. I found the one reference, but this isn't indicative of the other one. There is one in the June 21st document, and paragraph 4 says alternatives considered, and the company just says the company evaluates potential wind development sites as they become available, focusing on the ultimate goal of determining if a site could provide an economically viable renewable energy resource that aligns with the requirements of PacifiCorp's IRP and or provides a net benefit. That's a more broad one. So let me find the one where you specifically talk about it.
So I don't know if I can help you out here. I could not find that specific mention of that in the DPU 6.1 but -10, but I did see something along those lines mentioned in DPU 18.2, which is just, as we talked about, was the appraisal for the interconnect portion of the project. Is that what you're looking for in that document?
Yeah, that probably would have been one of them. Mm-hmm.
On page 3, paragraph 4, is that what you're referring to of the DPU 18.2 document, the appraisal document?
Yeah, but that would have just been the one with respect to transmission alternatives.
Yeah, and I guess that was my question, is that I didn't know if that's what you were relying on, because I think this document says no alternatives were considered, but that's referring to the transmission line, right?
Right. So that was one example. No alternatives considered. Okay, so I'm going back to GPU 6.1-10 where there were like a half a dozen different APRs or project change notices. So that's where I'm looking right now because I believe that's where they were contained. They're contained. But basically, the company said that they didn't consider any alternatives. So
It sounds like you're looking at something other than what we've marked as cross exhibit 10. Am I following you?
yeah, it's part of set 18, but it may not have just been 18 point. It may have been broader than just 18.2.
Are you still looking, or should I?
No,
on.
no. Okay, sorry. I pulled up 18, and let me see if 18.1. I believe 18.1 is the same as your response to 6-1-10. Is that correct?
I don't have that in front of me, so I can't opine on that.
Yeah, it is because I pulled this one up, and that it is the same. It has the same sentence that I just read to you. So let me just stick with the other documents in set 18.
Okay, well, I think we can confirm and clarify for the record that the statement that no alternatives were considered is in the transmission document, meaning that the company didn't consider an alternative transmission route or connection mechanism for the project, right?
It is in there, but it is also in other documents for the not just the transmission project.
Okay, but you didn't cite any of those other documents in your testimony, right?
So I'm looking at the investment appraisal document from the 2015 to 2020, which is part of set 18 provided to the division. And on page 3 of 6, number 4, this one says no alternatives were considered as part of this project as it is a customer request.
Correct, and that's referring to the interconnect request, right? The customer request is the request from Pacificor to Rocky Mountain Power to connect the facility, the Prairie Mountain facility, to the grid, right?
Yes. Mm-hmm. So it's in that one. And
okay.
I think it's in each of those.
Okay, and those documents that were produced in response to it's set 18 or transmission documents. So I think we move on from that. Let me ask you a follow-up question that hopefully doesn't rely on any documents. You heard Mr. Link's testimony that he, did you listen to Mr. Link's testimony?
I heard parts of it.
Okay, did you hear him explain that when he analyzed the Prairie Mountain project, he's analyzing the system with the project versus the system without the project, right?
Oh, I read that in his testimony. Mm-hmm.
Okay, so that's considering an alternative, right? Considering not building the project as an alternative to building the project, right?
Yeah, I mean, considering not doing nothing versus to doing something doesn't mean that the something is, produces benefits. So that doesn't really tell us a lot.
Well, Mr. Link's analysis shows the system benefits of the project as compared to not building it. That's what his analysis endeavored to show, right?
Yes.
Okay. You mentioned in your testimony about the production tax credits expiring in 10 years. You recall that portion of your testimony?
Yes.
And you understand that Mr. Link's analysis assumed that to be the case, right? The 10-year duration of the production tax credits is built into his analysis, right?
Correct.
Okay. And you made a statement that you believe the project is uneconomic without the production tax credit benefits and also the rec benefits associated with this project. Is that your testimony?
That's what the company. That's what the company responded to me in a data request. And yes, it is.
Okay, but those are not speculative benefits, right? The project will qualify for the production tax credits, right?
Yeah, we would hope so. We would like a guarantee that it does.
Okay, and you understand there's a binding contract with Vitesse whereby they will purchase the rec credits associated with the project?
Yes.
Okay, so it's sort of a hypothetical to analyze the project without those rec and production tax credit benefits, right?
Yes.
Now, you also mentioned in your testimony that you mentioned in your summary several administrative tasks that the company will need to do in order to get transmission interconnections to the project. Do you recall what those items that you mentioned in your summary?
I do recall those, and based on Mr. Van Engelenhoven's testimony today and Mr. Hemstreet's testimony, I have a little bit clearer understanding of that. In the repowering docket, Mr. Hemstreet talked about how they might have to go one and one and hook it up and then disconnect it and hook it up and disconnect it because the transmission wouldn't be built yet. But it appears now that because of the COVID, that's one benefit in that it buys time for you guys to get enough transmission infrastructure in there that you can do a circuit at a time, like was explained yesterday, and keep it energized and then do the next circuit. So yes, I have a clear understanding of that than what would have been the case without the transmission available.
Okay, so you're talking about, I believe, bringing the circuits online in groups, and you feel like that concern has been addressed adequately by Mr. Van Engelenhoven. Is that correct?
Yes, although the only concern is, and I don't know if he knew this, but what additional costs would be by energizing it that way.
Okay, and so you had also mentioned the pre-commissioning issue. I just want to make sure we're clear. Well, then a third issue that you raised in your summary was IRS certification. So I just want to be clear, those are three distinct things, right? The IRS certification, commissioning, and then energizing and bringing online, right?
I understood the IRS commissioning to be when, as Mr. Engelenhoven discussed, or it could have been Hemstreet yesterday, but the two people, they climb up the tower, they check all the circuits, they do some telemetry testing, and make sure they're energized and that they're working and they check off the boxes and there's power to them. And I kind of understood that to be two in one things. That was my understanding of the commissioning.
Okay, so I agree with what you just said, that is what Mr. Van Engelenhoven described as the commissioning components. But when you mentioned IRS certification, that is just a application that you file with the IRS. Do you understand that?
I didn't. I just thought at the time that they commissioned that the IRS certification was just, a check or whoever verified it, whoever is there sends a report and says, okay, this has been done.
Okay, I just want to make sure we're not conflating two concepts here or talking past each other. And so the commissioning, which Mr. Van Engelenhoven described, you understand that can only be done turbine by turbine. You need to send a person up there to turn it on, basically. Yeah,
that's been my understanding all along.
Okay, and that was the cost associated with commissioning as part of, do you understand that that's part of the agreement with Vestas, that cost is sort of baked into that contract?
No, I didn't, because like I say, I didn't realize until yesterday that, you guys have kind of regrouped all this into one big contract, and it was never supplied to the division to review as part of the project's demonstration of prudence. So I did not understand that, but I mean, I take your word that that's how it's done.
Okay, well, Mr. Van Engelen's word, right?
Yeah, his word, yes.
Okay. Okay, and then as far as placing the circuit in service, circuit by circuit, Mr. Van Engelenhoven, I think, explained that there's not an additional cost associated with that, right?
I don't know that he outlined any costs. No, I don't. I mean, it was probably part of the Vestas supply agreement, right?
Well, that's the commissioning. So now we're talking about the placing in service and energizing. That's part of the process of bringing the project online, and doing it circuit by circuit.
Mm-hmm.
Mr. Van Engelenhoven explained does not result in incremental costs as opposed to doing it all at once, right?
Yeah. Yes.
Right. And in fact, the bringing it online circuit by circuit is what allows the project to start delivering energy and benefits to the customers as soon as the circuits are available, right?
Right.
So since we're on the topic of, yeah.
Why don't we take a break right now and come back in about 15 minutes and continue?
Sure. Thank you.
Thank you. And Ms. Sherbert and Ms. Zinger, we can continue.
Okay, I'm ready. Dr. Zinger, are you there?
I'm here.
Okay. I just have very few more questions on the transmission issues that we were discussing. You mentioned in your summary that the company needed to amend the large generator interconnection agreement, or the LGIA. Do you recall mentioning that in your summary?
Yes.
There's no incremental cost associated with doing that, is there?
I would think there are costs, yeah.
What are you basing that on?
Well, if a customer wants to apply to get service, Pacific Corp Transmission doesn't do the system impact study and these LGIAs for free.
Well, the need to amend the LGIA was because there was previously one with a prior developer, but there was no project developed. You understand that, right?
That was a little tricky because I had to go through each one and determine if EverPower had canceled it, and then they froze it for 4 years, and then they opened it again, and then they changed the name, and that's the point when I thought Pacific Corp had taken over the project. So that was a little confusing.
I understand. Do you understand now, though, that it was just an amendment to the agreement that the prior QF developer had for interconnection?
The amendment to group all 3 projects as one project. Is that what you mean?
Correct.
Yes.
Okay, and you don't have any evidence to show that there was any cost associated with that, do you?
Yeah, I do believe there were costs. In fact, I recall the Oregon PUC disallowed those costs. In fact, at least, in their post-closing briefs, they did. That issue was never resolved. So there were costs for to do the study, and I believe part of it was they had to do some type of remedial action scheme, a test, or a RAS test that was approximately $800,000, and when they moved the point of interconnection from Wyoming up into Montana, another 15 miles, I think they had to restudy that configuration.
That's correct, because the prior developers had wanted to put the substation down in Wyoming so they could get the Wyoming QF rates, right?
Right.
And they were going to run the transmission down from Wyoming up to Montana to the project site, right?
Right.
Okay, and so then when the company purchased the project, it no longer needed to do that, right? It decided instead to build the substation right on the project site, right?
Right.
So that eliminated the need to run that transmission line from Montana down to Wyoming, right?
Correct.
Okay, so that resulted in a cost savings to the project, didn't it?
It did, but taken as a whole, there were still some transmission costs in there.
Okay. And those would be
interconnection agreement costs, the studies and things like that.
Okay, and there's transmission costs associated with any new wind project, right?
Right. At least to interconnection.
Right, and Mr. Link's analysis would have accounted for the cost associated with getting transmission to the project, right?
Yes.
Okay. Thank you, Dr. Zanger. I have no further questions.
Okay. Sorry, it took me, it was a little difficult to find everything, so thanks for being patient with me.
No problem. And actually, at this point, Mr. Chairman, I would move for the admission of Rocky Mountain Power Cross Exhibit 10, which was the APR document that was produced as DPU 6.1-10. And then I'll move for the admission of Rocky Mountain Power Cross Exhibit 11, which is the investment appraisal that was produced at DPU 18.2. And both of those are confidential documents.
Okay, and just to clarify, both are in the record already as DPU exhibits. Is that correct? Or are they DPU exhibits from different dockets?
They were produced in this docket. They're not attached to anybody's testimony.
Okay. Okay, and then with the clarification for the court reporter that these are confidential exhibits, let me just ask if there is any objection to that motion. I'm not seeing or hearing any objection, so the motion is granted. And with that, I'll go back to Mr. Jetter if you have any redirect for Dr. Zanger.
I do have a few redirect questions. Dr. Zanger, you referred earlier to your SIR rebuttal testimony for some cross-examination questions regarding a slide from the 2019 IRP. And that slide showed an entry there for a 240 megawatt wind facility in Wyoming. Do you recall that?
I recall that.
Okay. Where is the Fire Mountain Wind Farm?
I'm sorry, you cut out. Where is what?
Where is the proposed prior, or the actually under construction Prior Mountain Wind Farm?
Yeah, so it's in Montana. My understanding is it's, roughly up to 15 miles from the Franny location in Wyoming.
Okay. And would you have had a reason to know that a 240 megawatt Wyoming wind project that was in the 2019 IRP was in fact a Montana wind project?
No, I mean, the company's, this is the first wind project the company has attempted to acquire in Montana. So, that's news to all of us.
And so one reference to the slide in 2019 may not have given you meaningful notice that a project in Montana was under development.
Correct, especially, if it was a Friday, it was incidental in one bullet point and it did say Wyoming, so I don't think it caught people's attention.
Okay, thank you. And I'd like to ask another question that's a little bit different, but also related to the IRP process. When the company goes through the development of a preferred portfolio for the IRP, they don't evaluate each potential project on its own merits as a thumbs up or thumbs down revenue requirement comparison, do they?
No, in fact, they don't take each project, whether it's this or a solar project in Wyoming or Utah, and run the model and then run it without the model and then with the model.
And they do
that's not the way. Yeah, the model is, that's the point of the model, to optimize. The model optimization is that all the inputs are in the model and the system optimizer runs and optimizes, and out of all the possible supply side and demand side resources, the model selects the least cost, least risk resource. So yes, that's.
Is it fair characterization that you could potentially have 100 projects that pass the test, I guess you'd call it, individually, but the company only needs 10, and so the IRP would select the 10 best.
Yes.
Correct?
Yes.
And so there's a little bit more to it than a decision of build or not build.
Correct. Exactly.
It's a comparison to other alternatives that may be more economical.
Yes, and it's a comparison of a point in time. So for this given point in time, we put in all these inputs and gas prices and forecasts, and the model selects the least costly resource.
Okay. And the prior mountain was constructed outside of the IRP, to your knowledge, unless it was the Wyoming identified wind project that's actually in Montana.
Yes, correct.
Okay. Those are all of my questions.
Mr. Jetter, I'll ask if any of the parties other than Rocky Mountain Power have any recross to please indicate to me that you do. I'm not seeing or hearing any desire for recross from the other parties, so I'll go to Ms. Sherman. Do you have any recross?
Very quickly, thank you, Mr. Chairman. Dr. Zinger, you understand that the Prior Mountain Wind Project ties into the company's transmission grid through Wyoming?
Yes, they are building a tie-in up in that area of Franny Yellowtail is the way it's described.
So it makes sense that the company categorizes this as a Wyoming wind project because it ties into the grid through Wyoming, doesn't it?
Yeah. Yes, it does.
Okay, no further questions. Thank you.
Thank you, Ms. Sherman. Commissioner Allen, do you have any questions for Dr. Zinger?
No questions. Thank you.
Thank you, Commissioner. Commissioner Clark, do you have any questions?
I have no questions. Thanks very much.
Okay. I'll just ask Dr. Zinger, does anything that's been discussed this morning lead you to change any of your recommendations in your testimony?
Yes, it does. Like I say, it's been the division's understanding through discovery that the company's decision to pursue this project was made in June of 2019, and that changes a lot of things that happened from June 2018 to 2019. So if all of these things have already been done and this due diligence has been done, then that's a whole different decision when it comes to was the company's decision to pursue this project at this time in June. Would a reasonable utility would have pursued this? And I would say yes.
Thank you. I don't have any further questions. Thank you for your testimony yesterday and today. And thank you for your patience with our technology issues.
Oh, thank you for my issues with technology. Thank you.
Mr. Jetter, anything else from the Division of Public Utilities?
We have nothing further for this hearing. Thank you, Chairman.
Okay, I'll go to the Office of Consumer Services then for your first witness.
Thank you. The office would like to first call Allison Anderson as a witness.
Good morning, Ms. Anderson. Do you swear to tell the truth? You are muted still. You're showing on my screen as still being muted and we can't hear you. I cannot unmute you from my end.
If we could have just a minute, we'll help Allison get connected up with us, okay?
Sure. Ms. Anderson, if you're using a browser, typically you have to move the cursor around near the bottom of the screen before the buttons pop up. It's a little tricky to get them to pop up that way.
Could we just have about a 3 or 4 minute break? I think we have technical staff that can assist her in getting that going.
Sure, that'd probably be better. Why don't we take a 5-minute recess?
Thank you.
swear to tell the truth?
I do.
Okay, thank you. Mr. Snar, go ahead.
Thank you. Miss Allison, could you please state your name and spell your name for the record?
My name is Allison Anderson, ALYSONANDERSON.
And could you please still state your employment in connection with the office?
I'm employed by the Utah Office of Consumer Services as a utility analyst.
And in connection with your work as a utility analyst, have you participated in the office's preparation for presentations in this proceeding?
I have.
And in that connection, did you prepare Phase 1 revenue requirement direct testimony that was submitted on September 2?
I did.
And you also prepared Phase 1 revenue requirement surrebuttal testimony that was submitted on October 29. Isn't that correct?
Yes.
Is it also correct that you submitted direct testimony for the Phase 2 proceeding that will yet come to hearing in this case?
Yes.
Now let's focus on the revenue requirement testimonies, those submitted on September 2 and October 29th. Do you have any corrections to that testimony?
I do not.
And if you were asked the questions presented there today under oath, would your answers be the same?
They would.
With that in mind, we'd like to offer the admission of Phase 1 revenue requirement direct testimony submitted by Allison Anderson on September 2nd, as well as the Phase 1 revenue requirement surrebuttal testimony submitted on October 29th of this year. And just for clarification, there are no separate exhibits that are attached to either one of those testimonies.
Correct.
Thank you. If anyone objects to that motion, please indicate your objection. I'm not seeing or hearing anyone, so the motion is granted.
Hold on.
Sorry.
Can you hear me, Mr. Chairman?
Yeah, who's speaking?
Sorry, this is Matt Mosk, and I apologize that we were on mute. The power company has no objection to the admission of Ms. Anderson's testimony, her direct testimony, lines 1 through 59, which essentially introduce the OCS position and the witnesses that are testifying. The remainder of her testimony from line 61 through the conclusion and her surrebuttal deal entirely with the subscriber solar program, and they rebut witnesses or direct testimony that the company had proposed to put forward, but in fact, the company did not admit onto the record. Therefore, it would be improper to have on the record a testimony rebutting non-existent testimony, because none of the company's subscriber solar testimony was ever admitted onto the record as that was withdrawn. So we just, again, we don't have an objection to her introductory testimony, but we think it should be limited to that, and the subscriber solar portion should not be admitted as an actual piece of testimony on the record.
Mr. Snar, would you like to respond to that?
I can respond. The representations made by the company are true, and we're not going to pursue any of the subscriber solar testimony. Ms. Anderson was going to make that clear in her summary, but I think it is probably appropriate to excise those lines as far as what's being admitted today. I apologize we haven't had that excised previously, but I do not object to the motion made by the company in this regard.
Okay, thank you. So with that clarification, we have a motion to admit, am I correct, lines 1 through 61 of Ms. Anderson's direct testimony?
Yes.
Okay, if anyone objects to that motion, please indicate your objection. I'm not seeing or hearing any, so that motion is granted. And go ahead, Mr. Snar.
If we need to clean that up in terms of the actual submission, we can do so, but I think the record is clear. Ms.
If
Anderson,
anyone, oh,
go ahead.
no, to respond to that, if anyone feels the record needs to be clarified, feel free to submit a motion to that effect. Otherwise, we'll consider it covered.
Thank you. Ms. Anderson, have you prepared a summary of your testimony as it relates to those items that are not part of the subscriber solar?
I have.
Could you please present that at this time?
Yes, thank you. Good morning. My testimony provides the OCS's policy on the company's proposed expansion of the subscriber solar program, and it also introduces the Office of Consumer Services witnesses in the Rocky Mountain Power general rate case. Rocky Mountain Power has removed the expansion of the subscriber solar program from this case, and so now my testimony simply introduces the other OCS witnesses in this phase of the general rate case. Dr. J. Randall Woolridge previously presented the OCS's recommended cost of capital of 6.9%, including a return on equity of 9% and a 50-50 capital structure. Witness Donna Ramus presents the OCS's rate base and net operating income adjustments and provides the analysis behind the OCS's proposed revenue requirements. Witness Phil Hayek presents the OCS's recommended adjustments to base net power costs and for the disallowance of certain wind resources. Ultimately, the OCS is recommending a reduction of $37,257,110 in Rocky Mountain Power's Utah revenue requirement. And that concludes my summary.
Thank you. Ms. Anderson's available for cross-examination.
Thank you, Mr. Snar. Mr. Jetter, do you have any questions for Ms. Anderson?
I do not have any questions. Thank you.
Thank you, Mr. Russell.
No questions. Thank you.
Mr. Holman?
No questions.
Mr. Sanger?
No questions. Thank you.
Mr. Bain? Mr. Moskin, any questions?
No questions, and I apologize for the interruption, Ms. Anderson. Thank you.
Thank you. Commissioner Clark, do you have any questions for Ms. Anderson?
I have no questions. Thank you.
Commissioner Allen?
I also have no questions. Thank you.
Thank you. I don't either. So thank you for your testimony this morning. And Mr. Schnarr, you may call your next witness.
Thank you. The office would like to next call Ms. Donna Ramos as a witness.
Good morning, Ms. Ramos. Do you swear to tell the truth?
I do.
Thank you.
Ms. Ramos, will you please state your name and spell your name for the record?
My name is Donna Ramus, D-O-N-N-A-R-A-M-S.
And could you tell us where you're employed and what your relationship is with the office?
I'm self-employed as a regulatory consultant, and I work as a consultant for the Office of Consumer Services.
Thank you. And in connection with that assignment, have you participated in this proceeding and prepared testimony and exhibits for submission?
Yes, I have.
And does that include the direct testimony that was submitted on September 2nd, including various exhibits numbered 1, 2, 3, and 4 with subparts?
I had exhibits number 3.1D through 3.22D that was filed with my direct testimony.
Okay, I maybe used a different label. I'm sorry. And with you also filed surrebuttal testimony. Is that right?
Yes, I did.
And could you identify the exhibits attached to your surrebuttal testimony?
exhibits OCS 3.1S through 3.5S.
All right. And in connection with the testimony that's been prepared and submitted, first let me ask, do you have any corrections to the testimony as it has been submitted?
Yes, I have a couple typographical errors in my direct testimony that I would like to go over at this time.
Please go ahead.
Okay, the first, I have two corrections on page 52. The first one on line 1132. The $2,387,635 should be changed to $2,398,736. On the following line, 1133, the $56,100,427 should be changed to $56,095,326. And this does not impact the overall recommended revenue requirements as it deals with the AMI program that was updated by the company in its rebuttal. The next changes are page 53, line 1148. The $101.3 million should be $110.3 million. And down at the bottom of that same page, line 1166, the same change. 101.3 million should be 110.3 million. And this does not impact the revenue requirement calculation. And then one final change on page 78, line 1715. The year 2020 should be changed to 2021. And that completes the corrections.
Thank you. And if you were asked all those questions today in your testimony, would your answers be the same as presented there and as corrected per your comments this morning?
Yes, they would.
All right. The office would move for the admission of Ms. Ramos's direct testimony. It was submitted on September 2 with its accompanying exhibits, as well as its the surrebuttal testimony that was submitted on October 29th with the accompanying exhibits.
Please indicate if anyone has an objection to that motion. I'm not seeing or hearing any, so the motion is granted.
Thank you. Mr. Ramos, have you prepared a summary of your testimony for presentation today?
Yes, I have.
Could you please provide that now?
Yes, thank you. Good morning, Chairman LeVar, Commissioners Clark and Allen, and others attending this hearing. The facts and circumstances of this case show that Rocky Mountain Power's current rate should be reduced and not increased. Due to delays in portions of the prior Mountain and TB Flats wind projects, the company has proposed a two-step change in rates in its rebuttal position, and the OCS did not object to this two-step approach. As indicated in my rebuttal testimony, the recommendations of the OCS in this case result in a recommended reduction in current revenues of approximately $37.3 million after both step changes are considered. This consists of a recommended reduction in current rates of approximately $50.9 million effective January 1st, 2021, followed by an increase in revenue requirements of $13.67 million effective with the step 2 rate change. These two changes result in the overall reduction in current rates of approximately $37.3 million. As explained in my rebuttal testimony, many of the issues raised in my direct testimony have been resolved by this phase of the case, with the office and Rocky Mountain Power now in agreement in many areas. The company has agreed to several of the recommendations made in my direct testimony. The OCS does not take issue with many of the revisions made by the company in its rebuttal filing. My rebuttal testimony discusses several issues that remain in dispute in this proceeding, and I will briefly summarize my position on several of the outstanding issues in the order in which they appear in my rebuttal testimony. The first issue is the transmission power delivery bad debt expense issue. Base year expenses, which carry forward to the future projected test year, included approximately $980,000 for amounts recorded in a general ledger account for transmission power delivery bad debt expense, with a portion of these costs allocated to the Utah jurisdiction. In response to discovery, the company explained that the cost recorded in this account is for bad debt expense associated with transmission power delivery customers, including interconnection study costs that exceed customers' deposits and customer collections, which were then written off. The amount written off included $922,000 associated with a single customer. The transmission power delivery customer suspended the project involved and has challenged the amount due to the company. The company is still pursuing options to resolve the issue under the agreement with the transmission power delivery customer. I recommend that the transmission power delivery bad debt expense the company allocated to Utah in its filing not be included in the revenue requirements and passed on to Utah customers in this case. The next issue is generation overhaul expense. These expenses fluctuate from year to year depending on the timing of plant overhauls, the extent of the overall work, and whether the costs are capitalized or expense and how that spread is. For determining the amount of generation overhaul expense to include a revenue requirement, the office, Rocky Mountain Power, and the division are in agreement that the amount should be based on a 4-year historic average cost level. The issue for the commission to decide in this case is whether or not those historic costs should be escalated prior to averaging. This issue has been addressed extensively in prior proceedings and again in this proceeding. In the 2 proceedings in which the commission addressed the issue in an order, the commission determined that the historic costs should not be escalated. I recommend that the commission continue this practice and not escalate the costs prior to averaging. It is my view that the application of inflation to the historic amounts does not factor in productivity offsets, experience gained from prior overhauls that leads to efficiencies and cost savings measures. Nor does the application of inflation take into account the potential impacts of approaching plant retirements and early retirements on the extent of future overhaul work. The next issue I address is the escalation of non-labor O&M expenses. In its initial filing, the company escalated these non-labor O&M expenses using industry-specific escalation factors developed by IHS Markit in its 4th quarter 2019 forecast that was released in February 2020. In my direct testimony, I recommend that those factors be updated based on a more recent forecast released by IHS Markit. These more recent factors result in negative escalation rates for some but not all of the FERC accounts. My recommendation to update for the more recent escalation factors forecast by IHS Markit were consistent with PacifiCorp's position in an ongoing Oregon rate case. Rather than agreeing to also reflect updated factors in this Utah proceeding as it did in the Oregon proceeding, the company instead removed the application of escalation factors in its rebuttal filing. I continue to recommend that the base year non-labor O&M expenses be escalated to test year levels, and that is the forecast period levels, using the more recent industry-specific escalation factors. Application of the escalation factors to base year non-labor O&M expenses is consistent with prior Rocky Mountain Power rate case proceedings, consistent with PacifiCorp's approach in the concurrent Oregon rate case, and consistent with the Commission's findings on this issue that was recently affirmed in Dominion Energy Utah rate case. The next issue addresses the Deer Creek Mine closure regulatory asset. OCS is in agreement with Rocky Mountain Power that a portion of the protected property, plant, and equipment EDIT amortization regulatory liability, this is the tax benefit regulatory liability, it should be used to offset various regulatory assets in this case. The only difference between the office and the company regarding the amount of regulatory assets that should be offset pertains to a single component of the Deer Creek mine closure regulatory asset. That component is the estimated recovery-based royalties included by the company. As explained in my testimonies, these recovery-based royalties are not yet known and measurable and have not yet been paid by the company. The company indicated in response to discovery that I believe was attached to my direct testimony that it had not yet begun negotiations with the Office of Natural Resources Revenue to settle the amount owed. Rather than offset these estimated future potential payments with the known existing regulatory liability, I recommend that the recovery-based royalties be addressed in a future rate case after the amounts are known and have actually been paid. There is no harm to the company in deferring the costs, and there is the potential that the company will receive overriding royalties on coal produced from fossil rock coal reserves that would offset these costs. The next issue that remains in dispute is the treatment of the Utah Advanced Metering Infrastructure, or AMI project. Due to delays in the project, the company has substantially reduced the amount included in the average test year plant and service that was forecast, going from approximately $56 million in its direct filing to $12.4 million in that average plant and service in its rebuttal filing. While the company has included a portion of the estimated project costs in the test year, it has not included any of the anticipated cost savings or anticipated resulting increase in revenues. As explained in my testimony, the company has indicated in response to discovery that none of the identified benefits associated with AMI functionality and none of the ways in which the project drives a more customer-driven delivery strategy will be realized during the test year. Such benefits are not anticipated by RMP to be realized until 2023. Well, RMP witness Mansfield revised this position slightly in his rebuttal testimony, indicating few of the benefits for some of the customers are anticipated to begin during the test year. None of the potential cost savings were included in the test year. I recommend that the Utah AMI project be excluded from the test year, as the benefits of the project are largely not expected until 2023 when the project is fully implemented. The purported benefits are not reflected in the test year, and the project will not be fully used and useful in the test year. The next issue and several following issues pertain to pension expense. The key issue in the case is how a projected 2021 settlement loss should be treated for purposes of determining the amount of pension expense that should be included in revenue requirements resulting from this proceeding. As background, certain actuarial gains and losses that result from changes in the actuarial assumptions and the difference between the actual and expected pension plan experience are not recognized fully in the period they are incurred. Rather, and in general, the actuarial gains and losses are amortized and recognized as part of the pension cost calculations over the average remaining life expectancy of the pension plan participants. This smooths the impacts of both actuarial gains and losses on the annual pension costs and helps to avoid extreme fluctuations in the resulting annual pension costs that would otherwise be caused by changes in actuarial assumptions and plan experience deviating from what was projected. Under the company's pension plan, certain non-union retiring employees can elect to either receive a lump sum cash distribution or an actuarial equivalent life annuity upon their retirement. If the aggregate lump sum cash distribution to plan participants in a given calendar year exceeds or is greater than a certain threshold amount, a portion of the previously unrecognized actuarial gains and losses must be recognized immediately instead of amortized over time. This is what causes the projected settlement loss for the 2021 test year in this case. The company anticipates that the lump sum cash contribution to be paid to retiring employees during 2021 will exceed the threshold. In this case, the company has proposed to include the full amount of the projected 2021 settlement loss, totaling $11.9 million on a total company basis, as a component of the pension expense included in the revenue requirements. I recommend that on a going forward basis, beginning with the test year, the Commission allow the company to defer settlement losses or settlement gains that are triggered by the annual lump sum cash distributions exceeding the threshold, and to recognize such deferred settlement losses or gains as part of annual pension costs over the remaining life expectancy of plan participants. In other words, the actuarial losses or gains would continue to be recognized in the annual pension costs the same way that they would have otherwise been recognized if the settlement loss had not been triggered. Under this recommendation, the company's estimated test year settlement loss of $11.9 million would be amortized over a 21-year period. This is consistent with the treatment that the company requested in docket number 1803548. While the establishment of this deferral method of accounting may not have been appropriate as part of a request for accounting order in that docket, such consideration is appropriate and reasonable in the context of a general rate case proceeding. The next issue around pensions is the pension balancing account. The company has requested a balancing account for the first time in its rebuttal filing as an alternative proposal. Under this proposal, the company would still include the full projected 2021 settlement loss and pension expense instead of amortizing the amount as recommended by the office and UAE both. Under this new alternative proposal, starting with the rate effective date of this case, the company would defer the difference between the amount of pension expense included in revenue requirements and the amount that it actually books, resulting in a regulatory asset or regulatory liability. I do not recommend that the Commission adopt this 11th hour approach presented by RMP in its rebuttal filing less than 1 month prior to the start of hearings in this case. It would result in a substantial shift in how pension costs are treated for rate-making purposes in Utah. The company has accounted for pension expense using the actuarial or the accrual method of accounting for over 30 years, and the pension expense has been included in revenue requirements based on that accrual method of accounting for a long, long time. I do not recommend that now, many years after the transition to accrual accounting, and now that those plans are closed to new participants with the benefits frozen, that a new balancing account approach be implemented. The next issue addresses the net pension and post-retirement welfare plan prepaid asset. In this case, the company has included the projected test year prepaid pension asset and accrued other post-retirement assets, net of the associated accumulated deferred income taxes, as a component of rate base. This results in $110.3 million on a Utah basis being included in rate base in this case. RMP first proposed to include a net prepaid pension asset in rate base in its most recent prior rate case, which was resolved through a settlement, which was silent on this issue. Consistent with my position in that last rate case, I continue to recommend that the net prepaid asset and other post-retirement asset be excluded from rate base. As background, the prepaid pension asset and other post-retirement asset is the difference between the cumulative total amount of pension expense and post-retirement benefit expense recognized by the company for accounting purposes on its books and the cumulative total amount of cash contributions made to the defined benefit plans. In other words, the balance of the prepaid asset is based on a running tally of the total amount of cash contributions made to these plans, less the total amount of expenses recorded over time on the company's books for the plans. Over the duration of these retirement plans, the total amount of cash contributions will ultimately equal the total amount of expense associated with these plans. The difference between the total cumulative cash contributions to the plans and the total cumulative booked expense can result in either a prepaid asset or an accrued liability to the company on its books. For many past years, the company was in an accrued liability position, and during that time, the associated liability was not included as a component that would have offset rate base. To the best of my knowledge, the company never requested to include either a prepaid asset or the accrued liability as a component of rate base until the last rate case in which there was a net asset balance. In my opinion, it would be unfair to charge ratepayers a return now that the company is in a net prepaid position when ratepayers did not benefit through reduction to rate base during the many past years in which the net accrued liability existed. Additionally, as explained in my testimony, the company has not demonstrated that the net prepaid balance for the test year was funded by shareholders. This is, in part, because the amount of pension expense and post-retirement benefit expense included in rates is not reset annually, while the actual expense booked by the company does in fact change annually. It cannot be determined that the prepaid balance on the company's books was funded by shareholders and not ratepayers. As also explained in my testimony, negative pension expense causes the amount of prepaid pension asset to increase. In years in which $0 is being contributed to the pension plan, a negative pension expense booked for accounting purposes will cause the prepaid pension asset balance to grow. It is my opinion that inclusion of the net prepaid balance in rate base is not fair or reasonable. I recommend that the net prepaid pension asset and accrued other post-retirement assets continue to be excluded from rate base. There is one remaining issue that I wish to discuss in this summary for the Commission, and that is what should be done with the remaining protected property, plant, and equipment EDT amortization regulatory liability that is not being used to offset the various regulatory assets in this proceeding. The company has proposed that the remaining balance be flowed back to customers over a 2-year period to mitigate the impact of its proposed increase in rates in this case. Since the office is recommending a reduction in rates in this case instead of an increase, I recommended that the remaining regulatory liability balance instead be amortized back to ratepayers over an initial period of 10 years, with the unamortized balance being reflected as a reduction to rate base. The balance remaining at the time of the next rate case could then be reconsidered to determine the best use of the remaining balance of that regulatory liability. As explained in my direct testimony, there are many options available to the Commission for returning this regulatory liability to Utah ratepayers. If the amount of revenue requirement resulting from the Commission's findings in this case results in a rate increase instead of the decrease recommended by the office, the Commission could select a shorter amortization period than the 10 years presented in my direct testimony. During the current public health emergency, it would be reasonable for the Commission to take into account the overall change in revenues resulting from its findings in this case when selecting the period over which to return that regulatory liability to customers. This is a great mitigation tool at the Commission's disposal that can be used to assist Utah ratepayers during these challenging times. And that completes my summary. Thank you.
Thank you. Ms. Ramos is now available for cross-examination.
Thank you. I'll go to the Division of Public Utilities first. Do you have any questions for Ms. Ramos?
No questions. Thank you.
Thank you. Mr. Russell?
No questions. Thank you.
Mr. Holman?
No questions. Thank you.
Thank you, Mr. Mayor.
I have no questions. Thank you.
Mr. Boehm?
No questions, Your Honor. Thank you.
Okay, thank you. Rocky Mountain Power?
Yes, I'm here, Mr. Saban. I'll be doing this, and I've, as with Ms. Sherman, I've moved over to the witness computer. Hopefully that will help so everybody can see. Ms. Ramos, thank you for being here today. I just have a couple of questions, and I'd like to start with one issue you didn't address in your summary, which was the question of property taxes. You did address those in your rebuttal testimony, correct?
Yes, briefly.
Okay. And my understanding of your rebuttal testimony is that you don't accept the company's property tax update from its rebuttal testimony. Is that correct?
I don't believe that's quite what I said. Let me get to that page. It was more that I wasn't. Oh, I'm sorry.
No. You go ahead. You go ahead. Show, you need to absolutely.
Yeah, it's a little difficult virtually to see who's talking.
For sure. Yeah. For sure. Take whatever time you need because, as you've seen, it's been harder for everybody, I think, involved. So no problem.
Yeah, I'm not quickly finding the page reference, but
I think I was referring, if it helps you, to page 9. I read in your rebuttal that toward the bottom of page 9, and maybe I have misinterpreted you, and if I have, then please, by all means, please correct me.
Yes, I believe you had. What I indicate is that I haven't reflected it in the revenue requirement. Based on where the issue stood at that point in the case, I didn't have enough information to determine if I agreed this update was reasonable or not. So therefore, I didn't include it. I did issue some data requests to try to get some more information from the company on its rebuttal position and that large increase in its rebuttal. And I was under the assumption that perhaps the division would have filed surrebuttal testimony addressing it that would shed more light on it for me. And that didn't occur. So I don't have a recommendation for the commission on that issue, if it should accept the company's direct position, its surrebuttal position, or its rebuttal position, or Mr. Alder's position. I don't have a recommendation on that.
Okay, so you're just, to the best of what you're saying here is you're not taking a position one way or the other, whether they should or shouldn't.
Whether it should be updated or not. No, I'm not. I'm not familiar enough with the issue to weigh in.
Okay, thank you. I'd like to switch now to the transmission power delivery bad debt expense question, which I think is actually where you did start your summary. I want to be clear of a couple of points here as we start off on this issue. You would agree, wouldn't you, that the goal, our goal in establishing a reasonable test year is we're trying to anticipate reasonably expected costs during that period of time, right?
Yes, I would agree.
Okay, and a secondary portion for the company in particular is that the company in that test year is trying to ensure that it's going to be able to recover its prudently incurred costs, right?
Yes, I would agree.
And if I understand your testimony on this bad debt expense, this transmission power delivery bad debt expense, I really tried to come up with a better acronym for this because it's so long to repeat that every time. If I just say bad debt expense, do you understand what I mean?
I understand what you mean, as long as the commission's very clear that this is related to transmission power delivery customers and not your Utah distribution customers.
Yeah, unfortunately, there's no vowels in any of the words, so to come in with an acronym made it very cumbersome. So anyway, I'll just refer to it as bad debt expense, okay? That bad debt expense, I take it you don't say anywhere in your testimony that you're alleging that the company didn't act prudently in all respects with regard to those particular transmission relationships that resulted in a bad debt expense, right?
No, the issue is more that it shouldn't be, it's my view, they shouldn't be recovered from the Utah customers.
Okay, and then I'll shift to that question now, which is, if I understand your position, you're saying that if we were to look at the column for the test year under the line item for bad debt expenses on this issue, you would put a 0 there.
No, not entirely. If you turn to page 28 of my direct testimony, I have a table there on line 600.
Hang on, let me get there. Hang on, did you say 28?
Yes, page 28 of my direct testimony at line 600.
Okay, I'm there. Go ahead.
Okay, this shows a breakdown of all of the uncollectible expenses that are allocated using the CN or customer count factor. This would exclude the bad debt expense specific to Utah customers. So these are only the bad debt expenses that are allocated by the company to multiple jurisdictions using the customer count factor. And if you look on this table, there's several general ledger accounts that the company includes in that subtotal in FERC account 904. My adjustment only pertained to the amount associated with general ledger account 550775 bad debt expense - transmission power delivery. I didn't adjust the remaining sub accounts that would go into there. So I guess I wouldn't agree that I would say the amount 0, because I do allow for the amount in there. There's 3 other lines there, which would leave, I believe, about $6,500 in the test year.
Well, let me just focus on, I'm on your page 28. Let's just focus on account 550775, right? You follow me?
Yes. Mm-hmm.
In that line item, you, in your proposal, would zero out that line. You would say there's nothing there, right?
Yes, because based on responses by the company, those pertain to power delivery, transmission power delivery customers. And the way the company described it in response to discovery is that pertains to items such as interconnection study costs, where the amount collected from the customer didn't fully recover those transmission study costs. And it's my view that those shouldn't be passed on to Utah customers.
I understand. For our limited purposes now, I just want to make sure the difference between you and Mr. McDougall is that Mr. McDougall says there should be a number in that line, whatever that number is, we'll come to in a minute, and you're saying there should be a zero.
Yes.
Okay. And I apologize if you hear pounding. The window washers in this building apparently have chosen the worst possible moment to clean the windows in the building, and you can see somebody actually hanging from a rope behind me, shadow in the window. So it's actually really hard to focus on the question. Guy is right.
It's hard for me to focus on you because I see his shadow behind you.
It looks, if this was, it would even be made better if this was Halloween, right? Somebody hanging from a rope outside of a this is, anyway, I'm sorry about the distraction. I apologize.
Would it be an appropriate time to break for lunch anyway? We're a few minutes early, but with that distraction, should we just go ahead and do that?
I'm happy to do whatever is convenient for the parties. I just didn't want people to think, I wanted to make sure I had an explanation of what was going on here.
I'm assuming you're not going to be able to finish your cross-examination before lunch anyway, so why don't we go ahead and break?
Okay, we'll do that. Thank you very much.
Thanks. Okay. Saban's questions for Ms. Ramus.
Ms. Ramus, can you hear me okay? Hopefully.
Yes, I can.
Great. I can hear you much better now without banging behind me, so thank you.
You're welcome.
Standing. When we left off, we were looking at page 28 of your, I think it's your direct, right? Oh, excuse me. Yeah, it was your direct. And you had pointed me down to a chart at the bottom of page 28. Are you still there?
Yes, I am. Or I am now.
And we had been talking about line item 55, or account number 550775, entitled Bad Debt Expense Transmission PD, right?
Correct.
And I had just asked the question, as between you and Mr. McDougall, the difference of opinion, as I understand it, is he puts a number in that account line item, whereas you would say it would be zero, and I think you said yes, correct?
Yes, I recommend zero. He recommends an amount based on a 3-year average.
Okay. If I heard your summary correctly, you acknowledge that there is, at least with respect to the $900,000 item, it's $981,000 expense item in 2019, that you acknowledge that the company has in fact written that off.
Yes, they've written it off, but they are still pursuing recovery of that based on a data response in the record. But for book purposes, they wrote it off.
Right, and you have an accounting background, and for book purposes, when somebody writes off an item, typically that means they don't have an expectation of recovery. Isn't that right?
It means they think it more likely than not that they won't recover it, but they are still pursuing it.
Okay. And I take it you're not taking the position that they're likely to recover that amount, right?
I don't challenge how they accounted for it, no.
Okay.
I have no way to know. I don't disagree with how they accounted for it.
And do I understand your testimony correctly that you don't also dispute that in the 5 years or 5 or 6 years that the company provided information about this particular line item, that in each of those years, the company has had some level of expense on that particular account, right?
Yes, extremely low with the exception of the test year, and I believe 2016, where there was another specific customer amount written off in that single year, another power delivery customer.
Right, so there's been an item in there every year, but it's fluctuated a great deal. Do we agree on that?
Yes, for most years it's extremely low, but there were certainly substantial amounts in 2 of the years presented pertaining to 2 specific customers.
Okay, and you acknowledge that this is an expense item that ultimately comes out of the company's bottom line. It has to come up with that either its own pocket or out of, or it's treated as a normal expense and recovered through rates, right?
Yeah, it's an item that's expensed on the company's books.
Okay, and I want to be clear, under your proposal, then the company would get no recovery of any of these expenses in the test year, even though in every year it has had a number in that column.
In that specific sub-account, yes. It's my position, as I indicated in my testimony, the company hasn't provided reasonable explanation for why these amounts are being pursued to be recovered from Utah ratepayers. Again, these are transmission power delivery customers and pertain to interconnection studies. And I still didn't see an explanation in the company's rebuttal or in response to discovery on why those should be passed on to the Utah customers using the CM allocation.
Were you present during Mr. McDougall's testimony where he explained that very issue?
Yes, but I did not recall him explaining why those costs should be amounts that should be recovered from Utah ratepayers as opposed to transmission customers.
Okay, but you acknowledge this isn't a transmission. Well, I'll just leave it at that. You heard his explanation, and you haven't changed your position despite that.
Correct, I haven't changed my position.
Okay, Ms. Ramus, it is common, is it not, in regulatory rate making, where we have expenses that vary greatly from year to year, to use an average over that period of time, and to because we can't anticipate exactly what it's going to look like, we will take a multi-year periods and we will look at them and we will decide on a yearly period and we'll set an average, right?
For certain select costs, yes. For example, the generation overhaul expenses.
Right, that can vary wildly from year to year. We agree?
Yes, I agree with that.
Okay, just as this expense varies wildly from year to year, right?
Yes, I agree that expense varies wildly, but that does not mean I agree that those costs should be passed on to Utah customers due to the nature of the costs.
Okay, and we agree also that Mr. McDougall's rebuttal proposes to use an average over a 3-year period, right?
Yes, that's what he recommends.
Okay. And a final question on that point, if we don't have some category of some way to, some number in there, the company won't be able to collect any of this expense. You agree with that, right?
Not necessarily, because again, the company is including this in an account that it applies the CN allocation factor that it charges to Utah. I presume the company could allocate this cost differently. It does pertain to transmission power delivery customers. So just because it's not included in Utah rates through use of the customer count allocation factor doesn't mean the company doesn't have another way to recover those costs.
But as we said today, that's not how the company, that's not how this rate case has played out. This is an item of expense that the company has included, and you've said it should be excluded.
Correct.
Okay. I'd like to shift now to talk briefly about the AMI issue. I may or may not have been present. Were you present when Mr. Mansfield testified?
I was listening in. I wasn't in the hearing room, but I watched it on the live stream.
And if I understood your opening statement, I was a little confused because it almost made it sound like you hadn't heard his testimony. Do you understand him to have clearly stated that the company is only seeking in this rate case to recover those costs associated with the benefits that will actually be deliverable and available to customers prior to the test year?
It's my understanding that it's only related to those assets that the company anticipates to place in service during the test year. So some customers will be some number of AMI meter customers will be using sets. I would
right.
agree with that.
And if I have the number right, he anticipated about 35,000 customers at least would have that available to them, and he said, if not more. Do you agree with me that he did? He was asked to kind of quantify that, and he said it would be at least 35,000, but it could be more.
Yeah, I recall 34,000 something. But again,
okay.
The reasons I took it out of my testimony is not. I acknowledge in my testimony that some will be placed into service during the test year, but the cost savings associated with this project are not included in the test year. The company has included some of the plant going into service, and it's my opinion that does not properly match the benefits of those projects with the costs in the filing. There are none of the cost savings reflected in the test year.
Okay, well, let's just start here. Customers will, it's right, isn't it? The customers will be able to use the service and will be able to derive benefit. We can argue about what level of benefit, but they will be deriving some benefits from this service prior to the end of the test period, correct?
Yes, a small amount of customers. Oh, I'm sorry, was someone else speaking?
I don't think so, but go ahead.
Okay, I'm sorry. I thought I heard someone else speaking. No, some customers will have those new meters in place by the end of the test year. I agree with that. They'll be using those AMI meters. But the whole driver of this project, if you look at the requisition and the project approval forms, is because it's supposed to deliver benefits in the form of cost savings that offsets the cost of the project. So it's my opinion that while they're used and useful, they're not fully used and useful because the ratepayers, there's none of the the offsetting benefits reflected in this case.
Okay, I understand your position. I appreciate you clarifying. All right, I'd like to move now to the pension settlement question with you first. And I'll refer to the pension settlement loss issue just by that term, and then I will refer to the other as just pension and rate base. I'll try to talk about that separately from this first issue. I know you've treated them separately in your summary. So as it relates to pension settlement losses, as I understand your surrebuttal testimony, your direct testimony, you don't dispute that the company went out and figured out, using its best available information, what that settlement loss would be, what the amount would be. Do we agree on that?
Yes. They came up with their best estimate in consolidation with their outside actuarial firm.
Okay, and you're not arguing, I take it, that the estimate's not a reasonable calculation, or that it's not, that the company won't incur any settlement loss during the period of time at issue?
No, I'm not challenging the estimate they came forward with for the test period.
And you're not asserting that it's these are imprudent costs, right?
No, absolutely not.
Okay, so I think we can agree that because they're prudently incurred costs and the company has done its level best using all the information available to it to identify this cost, that there is a loss, there is a cost item that the company needs to recover somehow. Do we agree on that?
Yes, I agree that it's reasonable to allow recovery of those costs as part of the test.
Okay. And I'm just going to read a quote, and we can turn there if you'd like, but I think it might speed things up if I just read this. This is out of Ms. Koblia's rebuttal testimony. I'm referring to lines 51 through 56 if you want to follow along. But and as a prelude to this quote, Ms. Koblia explains that because there is this cost that's been incurred, there has to be some solution for collecting it. And she says there's three alternatives, and she lays, and then she reads, and then here's the quote: absent one of these alternatives, the company would not have the opportunity to recover pension settlement losses, which are merely amounts that would have otherwise been subject to recovery as part of net periodic benefit costs, absent the pension settlement accounting trigger. Both Ms. Ramus and Mr. Higgins acknowledge this, with Mr. Higgins specifically stating that he does not challenge the recovery of the forecast settlement loss. And that's the end of the quote. And today we've just established you don't argue either, that you don't challenge that this cost needs to be recovered either, right? That's right, isn't it?
No, in fact, I made an adjustment that would still allow for the recovery, just amortize
Right.
instead of all in a single year.
Right. And so you agree, I take it then, that the commission, the issue before the commission is, what's the best mechanism for the company to recover this cost going forward? Do we agree on that?
Yes, as in context with an overall revenue requirement determination for the test year, what's the best way to incorporate that projected pension expense and rates?
Okay.
For recovery.
And Ms. Koblia's proposed alternative is to use a balancing account for both pension settlement losses, as well as addressing all of the other pension issues we'll come to from the other pension expenses that are being addressed here in this rate case, right? That's her idea is, let's just have all of them put into a balancing account so we ensure both expenses and benefits are properly allocated between the company and customers. Is that how you understand her proposal?
She raises it as an alternative proposal, so I didn't take that as her primary recommendation. I took it as an alternative proposal for the commission to consider. But that's my understanding, that it's something, one of the methods she's offered as a way to address this issue.
Yeah, I appreciate that. Actually, in her direct testimony, she does say, you're correct, she says she initially proposes just to have the pension settlement loss included in the rate recovery, in the revenue requirement, right?
That's how it was presented in her direct testimony position. It wasn't until her rebuttal testimony and Mr. McDougall's rebuttal testimony that they raised this new balancing account approach. And I still read it as, she calls it, an alternative. So right. I took that as an option, not their primary position.
Fair enough. And she was offering that alternative because you and Mr. Higgins had raised concerns about the idea of just including the figure in entirely without some other way to deal with all other pension aspects, right? You were saying that you can't just look at this in isolation.
No, I was arguing, as I explained in my testimony, if not for the unique circumstances regarding the amount of retirees that take that lump sum cash benefit compared to the, what's the right word, the trigger that would cause part of those past losses to be recognized, if not for that occurring, these would have been amortized in as part of pension expense, those gains and losses, over the remaining life of employees. So I simply recommend that, consistent with what the company asked for in the recent pension docket, you treat those unrecognized gains or losses or potentially gains in the future as though that triggering hadn't occurred, and just continue to amortize those costs over the amortization period that would otherwise occur.
I understand. Thank you. And the 2018 docket you just referenced, that was only addressing pension settlement losses, right? It wasn't addressing any other pension-related issues. Isn't that true?
That was the company's request, but I know, for example, the office's position was that it wasn't appropriate to look at just that. Well, we had a lot of positions, but
I understand.
Yes,
Yeah.
but we did raise overall pension expense in that docket, and the resulting overall pension expense, not just focusing only on that settlement loss.
Well, but the company's proposal on the deferral was related in that docket only to pension-related pension settlement losses, correct? That's what your surrebuttal states.
Yeah, they had proposed to take out that one component of the determination of pension expense and defer just costs associated with that one component outside of a rate case proceeding. Right,
and the office's position was shouldn't be dealt with outside of a rate case. You need to go deal with it in a rate case, right?
Yes, and that's why I indicate in my testimony that now is the correct time to consider such an amortization approach.
Right, and the last thing I want to make clear on this pension settlement loss point is Ms. Coblia's proposal for a balancing account is not limited, as it was in the 2018 docket, to just pension settlement losses. She's trying to capture all of the moving parts of the pension accounts to make sure that not just losses, but all pension expenses and prepaid pension assets and all of that are properly accounted for, and that both the customer and the company are receiving the proper amount of benefit and or cost.
That's
right?
What she recommends, and I've disagreed with that recommendation in my testimony.
Right, I understand you have a different proposal, and I appreciate you explaining that. As it relates to the other pension, I'm going to shift now to the other pension issue, the more broadly, the pension-related expense issue. If I understood your testimony, your summary correctly, I think I heard you say that with regard to that issue.
I'm sorry, you said other pension expense issue. Are you referring to the balancing account or to the rate-based component?
Sorry, the rate-based component. Thank you for clarifying. Pension rate-based component. Yep.
Okay, thank you.
Let me just turn to my notes there. So as it relates, if I understood you correctly during your opening statement, you raised a concern that, or expressed a view, if I understood you correctly, that negative pension expense doesn't mean that the company has incurred any monetary consequence of that. That doesn't necessarily mean the company has to put out any money. Is that what I'm understanding you to say?
Well, this, again, the summary was taken from my presentations and my direct and surrebuttal testimonies. And as I explained, in a year where you have zero cash contributions, the company hasn't actually outlaid cash into the pension plan, but yet it records negative pension expense on its books, that would increase that prepaid pension asset that the company seeks to include in rate base.
Yeah, that's what I thought I heard you say. Okay. So I've just circulated an exhibit. It should be Exhibit 12, and I'm not sure if your counsel has forwarded that to you. Do you have Exhibit 12 there in your email?
I have something, let me go to the top to see if it has an exhibit number. I have a file that was called Douglas K. Stuver.pdf. I didn't
That's
see
the one.
number.
That's the one. Yep.
So that's number 12.
That's number 12. Thank you. If it's not in the email, please, everybody can note that's number 12. Okay. Would you open that testimony up and let me represent that this is Douglas Stuver was a witness for the company in the past, in the last rate case for the this very issue, this very you are raising now in your summary was asked of him in his testimony. And I want to read, we're going to start on page 18 of his testimony. It starts with line 399, and I've highlighted it for your convenience. Hopefully you've been able to see that.
Yeah,
I'd like to object. Are we trying to bootstrap testimony from a prior rate case into this case without bringing the appropriate witnesses?
I believe as part of being, Mr. Chairman, why don't you let me know?
Oh yeah, Mr. Saban, would you respond to Mr. Snar?
Sure, thank you. So no, I think that this issue came up in the last rate case, and for cross purposes, I think I'm entitled to use an exhibit that was presented in the last rate case on this very question, and that was part of the record in that last proceeding.
Well, the point is, I don't think it comes through as valid testimony to be considered in this proceeding, although you can ask questions of Ms. Ramos about positions or comments taken by the company in the past, but it doesn't rise to the level of testimony in this proceeding. It's just a tool for, if you're going to use it, it's just a tool to cross-examine her.
And I don't think I ever represented I was using it for any purpose other than that.
Very well.
I'm not offering Mr. Stuver as a witness here. He's not, certainly not on the list. Right. With that, am I okay to proceed forward with using this as a cross exhibit, Mr. Chair?
Yeah, my understanding of Mr. Snar's objection would be to a motion to admit this into evidence, which we don't have in front of us right now. So if there doesn't seem to be an objection to you asking Ms. Ramos questions relating to that. So why don't you go ahead?
Okay, thanks. Ms. Ramos, are you at line 399 there?
Yes, I am.
Could you read the question?
I'm sorry. I do recall him filing rebuttal. And I did not submit Sir rebuttal because my recollection is the case settled before I got to that point.
Okay. So would you read the question there at 399, and then we'll talk about the answer.
Aloud or?
Yes, please, aloud. Sorry. Thank you.
Dr. Powell asserts that the company failed to explain the implications to the company and customers of negative pension expense. Please explain these implications.
Okay, now would you read the answer that Mr. Stuver provided there?
Negative pension expense increases the prepaid pension asset and is appropriate to include in rate base because the company's cash position is reduced by the amount of negative pension expense passed to customers. For example, assume the company has negative pension expense of $10 million and no cash contributions. Customers in that instance receive a $10 million revenue requirement reduction, which directly translates into $10 million less in cash held by the company, regardless of whether the company has had $10 million less in cash because it contributed $10 million to the pension trust and had zero expense, or contributed zero to the pension trust and had $10 million in negative pension expense. The company's cash position is $10 million less in either circumstance, and the financing needs of the company are the same. Since FAS 80...
You can stop there for the moment. It's correct, isn't it, that the two hypotheticals he gives, if the company had $10 million in cash because it contributed, I'm going to start on line 408 there. He says, regardless of whether the company has $10 million less in cash because it contributed $10 million to the pension trust and had zero expense, or alternatively, contributed $0 to the pension trust, but had $10 million in negative pension expense. It's true, isn't it, Ms. Ramos, that in both of those circumstances, the cash position of the company is $10 million less for them. They have to come up with it somewhere.
That would only be true if that negative pension expense had been incorporated in rates in a rate case. And to the best of my knowledge, I know the company since the last rate case has had negative pension expense in several of those years, but I'm not aware of negative pension expense ever being included in rate charge to Rocky Mountain Power ratepayers as of this point. If you somehow trued it up each year and had a mechanism where you tied the amount of pension expense booked to the amount ultimately recovered from ratepayers, then there would be more merit to that.
Okay, and that is in fact what Ms. Cobley is proposing, right? Through a balancing account, is to do that very same true-up mechanism you just referenced. On
a going forward basis, but the problem is, coupled with that, she wants to include $110 million on a Utah basis, or $110.5 million, for historically accumulated prepaid pension assets, net of the accumulated deferred income taxes on the company's books. She's not proposing that going forward that now you start tracking it and that only the rate base amount to include in rate base be based on it after that true up or balancing account goes into effect. So that's a key difference.
You acknowledge, though, that she did do an analysis all the way back for many years to determine that looking over those past expenses doesn't help customers, because at the end of the day, the company has put out more than customers should have been offset. Isn't that right?
That's what she claims, but I'm not sure I agree with that because of how rates are set in Utah. There's not a true up each year. And in the test years where you're dealing with a test year in a rate case where there were negative prepaid pension assets, liabilities, pension liabilities, those weren't offset to rate base. And my recollection, I haven't looked at Mr. Stuver's summary in the last case, and I haven't looked at her exhibit in this case in a while, but you would almost have to assume that was trued up every year in rates, and it's not. That's not how it's done.
I understand your point, but let me go back to my original question, which was, you personally haven't done your own analysis to go back and look at how the pension account went back and forth as between expense for the company or benefits to the customers, right?
Yeah, I haven't gone back, and well, partly you can't do that because there have been so many settled cases that you don't know exactly what has been assumed in rates being collected from customers for pension expense. So I don't think you go back today and do that and figure out what was incorporated in rates in past cases compared to what was booked as expense on the company's books each year. There's too many gaps for the years where we had settlements without a specific amount identified for pensions in those settlements. I thought to try to do that in the prior case and realized there's an issue with that because of the settlement years. And I believe in the last case, the company couldn't go back all the way to the start of accrual accounting. I want to say they had information going into sometime in the 90s. So I just didn't have all the data you would need to do that.
Right, but we agree, right, that Ms. Koblia has gone back and compared over a period of a number of years, all the way up, I think, to the last rate case, and calculated that out, has she not?
Let me check her exhibit. I thought she had done her exhibit based on what was expensed on the books, and that was including revenue requirements charged from customers.
I think, are you looking at exhibit NLK-1RR?
Yes, that shows what balance was recorded on the company's books for the prepaid pension balance. But again, that doesn't show you what was recovered in rates from customers. and included in revenue requirements in past rate cases to be able to determine for that prepaid pension balance, how much of that could have been supported by ratepayers compared to shareholders.
Okay, and you raised in your statement, your opening statement, that question of, in your mind, there's uncertainty between whether customers are paying, have paid, or whether the company has paid, right? That's, if I understood your summary correctly, that was one of the issues you raised.
Yeah, it's my opinion that the company has not demonstrated that it's shareholders that have funded that prepaid pension balance.
Okay, and that uncertainty that you're referencing could be completely solved if you had a balancing account, would it not?
On a going forward basis, and just for comparing what's collected in rates versus the cash contributions on a going forward basis, that would tell you that, but I still don't recommend that you switch now this late in the pension plan life to a balancing account approach. It wouldn't be my recommendation.
I understand it's not your recommendation. I do appreciate that. And the deferred accounting approach you're proposing wouldn't be, that uncertainty would still continue to persist. Isn't that true? You wouldn't know necessarily from one year to another. At least it wouldn't solve your concern you raised during your summary. Isn't that right? The deferred accounting option.
Oh, going forward with regards to who's funding the difference, if depending on what the, going forward, no, it wouldn't.
Right. So help me understand what's the negative of doing a balancing account? Why do you oppose that when it addresses the very issues that you have highlighted in your summary are problems?
In general, it's very rare, extremely rare, that I recommend in cases that a balancing approach be done. It sets a not good precedent going forward, because then you have so many items that you're truing up between rate cases, and I don't think that's a good way to go about determining revenue requirements for utilities. Especially with pensions. I mean, if we, for the settlement loss issue, amortize that, you're not going to have the extreme volatility that's caused by the settlement loss, as you would if you were to recognize it all in 1 year. By amortizing it consistent with how it would be done otherwise, you're removing some of that volatility. So it's my opinion that there's not the level of volatility where I would recommend a balancing account. And in fact, I've seen other jurisdictions that had pension balancing accounts in the past that have discontinued them. I just don't think, now that accrual accounting has been in place since I think 87 or 88 for pension plans, and the early 90s for non-pension post-retirement benefits, that now 30 plus years out, you should switch to a balancing account approach for this. It's my opinion that it's not needed and it's not beneficial.
Let me ask two quick questions. Do you see any, there is no detriment from the idea of doing that, right? You're going to be ensuring things are properly accounted for on both sides of the ledger if you do that. Isn't that right?
You would be, but again, I just don't think that it's a good regulatory policy to shift increasing amounts and types of costs into balancing account approaches between rate cases. I just don't think it's good policy.
Okay, understand. Finally, on this question, you indicated that you didn't see that the need, the balancing accounts make sense where there's maybe some volatility or unpredictability in an area. Did I understand you correctly that's one area where a balancing account might make sense?
I'm not sure that I would recommend that still for pension and other post-retirement benefits, because again, I've worked in cases in other jurisdictions where it's been determined that the commission did not want to continue forward with that approach. So I just don't recommend, now that we're getting closer to the end of the life of these pension plans that have been closed for a number of years, new employees don't go into them, to now switch significantly in the approach of how these costs are recovered in Utah.
Yeah, I think my original question was just, weren't you saying a moment ago that balancing accounts can be an appropriate mechanism when you're dealing with volatile or unpredictable types of cost versus benefit analyses? Isn't that what you were saying?
In limited circumstances, like for example, for renewable energy credits here in Utah, I believe around 2012, quite some time ago, there was a lot of unknown and significant volatility in that account, where I agreed that at the time that balancing account approach was put into place, it was reasonable. You were going from 50 million one year to 20 some million in another year, and now we're down to around 3 million a year. So historically, under very limited circumstances, I would agree that balancing accounts can be reasonable and appropriate. I just don't agree that pension expense is one of those items that I would think we should move to a balancing account approach at this time.
And Ms. Koblia, in her testimony and including her summary, highlighted the fact that that she anticipates that there will be a lot more of pension loss activity than there has been in the past. In other words, there's not been a lot of pension settlements in the past, but she anticipates there will be going forward because of the nature of the pension, the way the pension account is now closed and the way interest rates are moving. That's true, isn't it? That it's likely that there will be more pension settlements given the economic circumstances and the nature of the pension account now than there has been in the past.
Yes, and that's why the recommendation I made for the treatment of that, as well as that made by UAE Witness Higgins, that would allow for those costs to be amortized over the life of the remaining plan participants, would take care of that. It would still allow the company to recover those costs, just as they would have otherwise been treated absent that unique circumstance that triggered the settlement loss. So under the method I've proposed, which is the same as the company had proposed previously in the pension docket, if there are settlement losses such as this between rate cases, say one in 2021, you have another one, let's say, for example, in 2023, you would still then take that amortization approach for those. So it would still smooth out that volatility and allow for recovery of those costs.
Right. My point was just simply that whereas in the past there has really not been a lot of pension settlement activity, we anticipate that to change, and it's going to, Mr. Higgins even says he thinks it's unpredictable and speculative, and therefore you ought to have some way of dealing with it in the going forward. That's right, isn't it?
Yes, and that's why both him and I recommended that these now be deferred and amortized consistent with how they would have been treated absent that settlement loss being triggered. That's in my opinion, a fair and reasonable way to address those and still allow the company recovery of those costs.
Okay. Mr. Chair, if you could give me just 1 minute, I want to just make sure I've covered everything, and I'll be right back. Is that okay?
Sure. Should we do a brief recess, or?
That's fine. I'm happy to, or happy to just be right back to you, whatever you'd prefer.
Okay, we'll just hold on.
Okay.
Thanks.
Okay, I think we're done. Thank you, Mr. Chair. Thank you, thank you, Ms. Ramus, as well. Appreciate it.
You're welcome. Thank you.
Okay, we'll go back to Mr. Snar for any redirect.
No redirect.
Okay, thank you, Mr. Snar. Commissioner Clark, do you have any questions for Ms. Ramus?
I'm chuckling because sometimes these buttons just want my cursor to chase them around, but I have no questions. Thank you, Ms. Ramus.
You're welcome.
Okay, thank you, Commissioner Clark. Commissioner Allen, any questions?
Thank you. I have no questions.
Thank you, and I don't either. So thank you for your testimony today, Ms. Remus.
You're welcome.
Mr. Snar?
Thank you. The office would like to next call Mr. Philip Hayat as a witness.
And I'm here. Can you hear me?
I can hear you fine, Mr. Hayat. Thank you for joining us.
Thank you.
Do you swear to tell the truth?
I do.
Thank you.
Mr. Hayat, will you please spell your name?
Yes, it's AJYET.
And would you tell us where you're employed and the association you have with the Office of Consumer Services?
I'm employed at J. Kennedy and Associates, Vice President of J. Kennedy and Associates, and I'm a regulatory consultant working on behalf of the Office, Consumer Services.
And in connection with your employment by the Office of Consumer Services, have you had occasion to study the submissions made by Rocky Mountain in this case?
Yes, I have.
And have you prepared testimony for submission in this case?
I have.
And that include direct testimony submitted on September 2nd with accompanying exhibits?
Yes.
And did it also include survey testimony submitted on October 29th with accompanying exhibits?
Yes.
Do you have any corrections or additions to any of the testimony or exhibits that you previously submitted?
Yes, I have a couple of small corrections to my direct testimony. It's actually the same correction, and I would correct lines number 40. I'm sorry, I have a list here. 40 on line number 48, 60, 95, and 106, where it has MPC, that should read revenue requirement.
Okay, and with those corrections, if you were asked today the questions in your testimony, would you provide the same answers in connection with the hearing today?
I would.
Based on that response, Chairman LeVar, we'd like to move the admission of the direct testimony and exhibits that was submitted by Mr. Hayat on September 2nd, as well as the surrebuttal testimony and exhibits submitted by Mr. Hayat on October 29th.
Thank you. If anyone objects to that motion, please unmute yourself and state your objection. I'm not seeing or hearing any, so the motion is granted. Thank you.
Mr. Hayat, have you prepared a summary of your testimony for this hearing today?
Yes, I have.
Will you proceed to provide that?
Yes, thank you. Good afternoon, Commissioners LeVar, Clark, and Allen. On behalf of the OCS, I initially investigated and discussed in my direct testimony issues related to net power costs, wind resources, and generating unit outages. My surrebuttal testimony provides the OCS's ultimate recommended adjustment to base net power costs. It supports a disallowance of the prior mountain wind resource, and it includes a disallowance for a long Lakeside 2 generating unit outage. Some of the issues raised in direct testimony have now been resolved. There remains a single net power cost issue, and it relates to the prior mountain wind resource located in Montana. The OCS recommends a disallowance of the cost of prior mountain because there is a lack of evidence demonstrating that it was a prudent investment decision. The OCS includes an adjustment to net power costs associated with the disallowance of the wind resource. The OCS recommends disallowance of the prior mountain costs because, one, it is more expensive than other recent acquisitions the company made in Docket 17-03540, the new wind docket. Number two, significant components of the wind turbine generators were based on affiliate transactions that have not been fully justified. Number three, it is not strictly needed to satisfy Rocky Mountain Power's resource requirements. And 4, the net benefit results the company identified are not compelling. That's a different standard approval of Prior Mountain due to its lack of pre-approval. Rather, since no review approved.
Mr. Hayek?
Yes.
Sorry, Ms. Harmon, I don't mean to cut you off, but I think we were both saying the same thing. We lost a little bit, so maybe if you could go back 2 or 3 sentences and repeat yourself.
Okay, I'd be happy to.
If you start right after the list of 4 items, I think that's where you were, Mr. Hayek.
Okay, I'm sorry. The OCS is not suggesting a different standard for approval of Prior Mountain due to its lack of pre-approval. Rather, since no review of prudence has been made to date, a full prudence review of both planning decisions and construction costs must take place in this proceeding. Rocky Mountain Power bears a full burden of proof to demonstrate prudence, which it has not done. Furthermore, the company provided limited evidence supporting a need for generating capacity. It provided no analysis of the net benefit of the project, considering the cost overrun and the project delay. And as we have now learned, more of the project will be delayed into the 2021 test year than had been expected when the company filed its rebuttal testimony. It is certainly possible that additional delays could be announced after this proceeding is over. With regard to the affiliate transaction, the company has provided no evidence to prove that the acquisition of components of the wind turbine generators from an affiliate was truly priced at the lower of cost of market. The fact is, the only evidence of any cost comparison of the project is a comparison that I provided that indicated the capital cost of the Prior Mountain project, when stated on a $ per kW basis, is substantially greater than the cost of the Energy Vision projects that are being reviewed for cost recovery in this proceeding. This gets to the question of the cost paid to the PacifiCorp's affiliate, and ultimately, Rocky Mountain Power provided no evidence that paying cost to an affiliate was a fair price for Prior Mountain based on the lower of the cost of market standard. However, as mentioned, there is evidence in this case that suggests that other resources were recently acquired at lower cost. Finally, the net benefits discussed in the company's testimony are not compelling and are out of date as it relates to the current and increasing cost of the project. Again, there is no critical need to add the Prior Mountain project, and this is particularly significant given that PacifiCorp knew it would soon engage in another competitive solicitation process, which is currently underway, that would likely add additional renewable resources to its system. OCS recommends that the PSC should find that the company has failed to demonstrate the prudence of its decision to move forward with Prior Mountain project, and it has not shown that it is least cost resource.
May I interrupt at this point in time? Chair LeVar, that constitutes the summary of Mr. Hayek's treatment of the Prior Mountain project. He does have one other issue that he'll be treating. We have a summary as it relates to that, but it would likely involve confidential information as it relates to the Lakeside 2 outage. We would like to merely identify that to you and ask for guidance on how you'd like to proceed, both for the summary that he would provide at this point and as to how we might deal with the questions that would follow on from that in cross-examination.
Considering that we've already dealt with the substance of the Lakeside 2 outage and whether that still remains confidential, and we've already made the decision that it does warrant confidential treatment, it seems to me it might be more efficient to do cross-examination on the Prior Mountain issue and then come back and start over again with Mr. Hayek on the Lakeside issue, if that's acceptable to both of you.
That's acceptable. We can do it in that fashion. We just wanted guidance and to alert everyone to the 2 issues, one of them being more confidential in nature, the other one not. So with that guidance, unless there's other direction. He's ready for cross-examination on the Prior Mountain issue.
Let me just see if there's any objection from any other party to splitting up his testimony in that way. I'm not seeing or hearing any objection. So with that, I'll go to Mr. Jetter. Do you have any questions for Mr. Hayat at this point?
I have no questions. Thank you.
Thank you. Mr. Russell?
No questions. Thank you.
Mr. Holman?
No questions. Thank you.
Mr. Sanger?
No questions. Thank you very much.
Mr. Boehm? Ms. Sherman?
Good afternoon. Thank you. Good afternoon, Mr. Hayat.
Good afternoon.
I do have some questions for you. I'm going to start with something that you mentioned in your summary, and that's also in your rebuttal about the prudence standard. You mentioned just now that the review and analysis that Rocky Mountain Power performed of the Prior Mountain project does not take into account any delays or cost overruns associated with the project. You understand that the statute that we're operating under in this proceeding calls for the commission to determine whether the utility was reasonable, judged from at the time the action was taken. Isn't that true?
Yes, I believe that's true.
And you understand here that the company made the decision to pursue the Prior Mountain project in 2019, correct?
That's correct.
Okay, and that was before COVID or any delays associated with COVID were foreseeable, right?
Yeah. As we've heard, there was no contingency considered, no consideration of a delay, consideration of the project at the time based on what was known at the time. Project would be completed by December. And so if we use the information that was known at the time, it was known that the project had absolutely no wiggle room in case of a delay, and therefore had it been delayed because of factors that could right now we don't know if it's all entirely COVID. It may be that it's entirely COVID, but at the time it wasn't known. All that was known was that it would be completed in December, and that was right before the PTCs, 100% PTCs would expire. Any delay at that point when the decision was made and this project was going to result in not achieving the goal of having 100% of the PTCs. That's what was known at the time.
Okay, so did you listen to my conversation with Dr. Zigner this morning?
And what are you referring to?
Sorry, you're breaking up a little bit. I didn't hear that response.
Yes, I did listen to the conversation, but so I think that's your answer. I was just asking what specifically you were referring to.
All right, I'll get there.
I think I can help. I meant to use my my apologies. I hope this helps.
Okay, we'll give it a shot. So I was going to ask, the discussion I had with Dr. Zigner this morning, we established that there was the APR document, the planning document for the budget approval and appropriation request. Do you recall my conversation with her about that?
Yes.
Okay, and we reviewed that document and established that at the time the project was submitted for approval, and we can take a look at it again if this would be helpful to you, the document, the company had already had a plan to secure all the turbines. Is that correct?
Yes.
And the only evidence in the record regarding the delays are related to COVID. Isn't that true?
Well, I don't think we know that. The project hasn't been completed. We know that COVID has had an impact. We don't know the full information about the project. So it could be that the project could be delayed for other reasons. And these kinds of reasons could have been discussed when people had people had an opportunity to consider risk. They may have been evaluated. I'm not saying COVID necessarily, but there could be other issues that would have gotten discussed at the time that pre-approval would have been considered.
Okay, so as I discussed with Dr. Zingner this morning, the availability of turbines and the ability to deploy them was a risk that was identified by the company in planning for the project, wasn't it?
Yes.
And they developed a mitigation strategy to address that risk, correct?
Yes.
Okay, and sitting here today, we know that all the turbines have either been delivered or are in the process of being delivered to the project, right?
Yes.
Okay. I would like to ask you about the capacity needs that you mentioned in your testimony and in your summary.
Yes.
You said that the project was not strictly needed. Are you familiar with the company's 2019 IRP?
Yes, I am.
And you're familiar with the planning that goes into formulating the IRP?
Yes.
And you understand that the IRP describes the company's preferred portfolio?
Yes.
And what is your understanding of what the preferred portfolio is?
The preferred portfolio considers proxy resources. It evaluates those proxy resources by analyzing proxy CTs, proxy combined cycle resources over the study period. Generally comes up with the idea of the type of resources that would be best suited to be constructed by the company over the period based on the information known at the time. The next step typically in the process after the IRP is a competitive solicitation, because you'll hear from utilities across the country that they generally never select a resource specifically as included in the IRP. They identify resources through a competitive solicitation process.
Okay, and is your understanding that the preferred portfolio is the least cost, least risk portfolio that the company, along with its stakeholders, has identified?
Yes, and in terms of identifying the type and timing of resources based on what's known at the time, based on considering proxy resources, it's considered to be the least cost resource plan at the time. However, as I mentioned, no decisions are made normally by any utility without then taking the next step of going through a competitive solicitation process. That's the normal process. I'm not saying that that's the only way that resources are ever acquired, but that's been the way it's been acquired mostly here in Utah for many years since I've been involved. And typically that's the way it's done by other utilities.
Did the court reporter wanted to make a comment? I saw her pop up.
Yeah, I did. There's just a couple times that he's freezing. I do think I'm getting everything, but there's things that are not being heard. There's every once in a while, I'm not confident that I'm getting 100% of the words when he freezes. Sometimes I feel like it fills it in, and sometimes I'm not sure.
I apologize.
Okay, it's not your fault. But if he freezes and somebody doesn't think you're hearing every single word, please ask him to repeat.
Okay, we'll move on and give this our best shot.
Okay.
You mentioned the competitive solicitation process. You acknowledge that under Utah's Energy Resource Procurement Act, there's no competitive solicitation process required for a renewable resource under 300 megawatt nameplate capacity, right?
I agree, but I would mention this is a very expensive resource. This is not an inconsequential cost. This is a resource that compares to the cost of the combined cycle resources that the company, over time. So it's substantial.
Okay, so going back to the IRP and the preferred portfolio, the office of that you're testifying on behalf of, they participate in the IRP process, right?
Yes.
Okay, and you're familiar that with the new wind resources that were identified in the 2019 preferred portfolio?
Yes.
I think I'm going to try to share my screen here. Let's see if this works. So it's not, how do I share an internet thing?
Within a window.
Thanks for bearing with me. I didn't realize the Chrome tab sharing option. So I pulled up the company's 2019 IRP. Do you see that?
Yes.
Okay, and I'm going to scroll down a few pages where it talks about the preferred portfolio. I think I went. Let's see here, ma'am. I think that is down here. Get to the preferred portfolio highlight section. Can you just read the section that I've highlighted there?
By the end of 2023, the preferred portfolio includes nearly 3,000 megawatts of new resources and more than 3,500 megawatts of new wind resources, inclusive of resources that have come online by the end of 2020 that were not in the 2017 IRP.
Okay, and then if we scroll down a little bit further, you can see this was the graph of the preferred portfolio of all resources, correct?
Yes.
And the wind resources are in green, and you can see that there is the new wind resources that were just mentioned in that sentence you read, correct?
Yes.
Okay, and then the blue is front office transactions, FOTs. Is that your understanding of what FOT stands for? Okay.
Yes.
And if we scroll down a little bit further, I think we can get to this graphic depiction of the new wind resources. And again, this is showing that the preferred portfolio includes more than 30 megawatts of new wind generation by the end of 2023, correct?
Yeah.
And let's see if we scroll down a little bit further. Wanted to get to the discussion of the front office transactions, which I believe is this pages 11 through 12. And this, let me just have you read this part. Sorry, I didn't highlight the whole thing.
Figure 1.9 shows an overall decline in reliance on wholesale market firm purchases in the 2019 IRP preferred portfolio relative to the market purchases included in the 2017 IRP preferred portfolio. Is that a question, or you're just asking me to read it?
I was asking you to read it. I'm going to ask you a question now. If my understanding your testimony correctly, it was in your rebuttal testimony, your position is that you acknowledge there was a capacity need, but your position is that the company could have filled that capacity need with front office transactions.
Well, can you possibly make this bigger? I can't. to see the graphs. Okay.
Sure.
As you noticed, 2019 relied on 1,000 megawatts of front office transactions. The system didn't suffer outages, as far as I'm aware, for a lack of having intermittent renewable resources. 2020 still shows considerable amount of front office transactions. Again, there's no expectation that December the system will suffer any significant problems for lack of the intermittent renewable resource. Similarly, in 2021, and I'd submit to you that the only impact of the prior mountain is it alters that bar that we see in 2021 by 50 megawatts. So there'll still be a considerable need for front office transaction. So the company has always relied on front office transactions.
I'm sorry, I missed the number of megawatts. Prayer Mountain is the alters the we see in 21, so there's still how many megawatts?
I think I mentioned that the front office transactions would only adjust the 500 megawatts we see here of front office by approximately 55 megawatts or thereabouts. So it doesn't have a significant impact on the system. So nobody should be under the illusion that without prior mountain, the company has a critical need for capacity and that it can't continue to rely on front office transactions.
Okay, so my question was, though, that's your position, is that it rather could have satisfied the capacity need with front office transactions. That's what you say in your SIR rebuttal, right?
That's what I say, and certainly there is a competitive solicitation process underway right now, and we will know what the least cost resources are from the competitive solicitation.
Okay, but you don't dispute that the company, in consultation with its stakeholders, identified in the 2019 IRP that the preferred portfolio would call for a reduction in the reliance on front office transactions, right?
No, I think the graph shows that there's a significant dependence on front office transactions. However, it is declining.
And the IRP, I'm going to scroll down, it also called for coal retirements. Do you see that?
Yes.
You understand that the company is planning to retire certain coal generating assets?
Yes, I do understand that.
And the preferred portfolio calls for the replacement of the capacity due to the retirement of those coal generation assets with renewable resources, right?
I understand that it does anticipate renewable resources to replace it.
It wouldn't be prudent to fill a shortfall capacity caused by the retirement of a coal generation unit entirely with front office transactions, would it?
Well, if you could go back up again to the graph. Again, 2020, we don't have the front office. Sorry, 2020, we don't have the prior mountain project. And while front office transactions are dropping, I submit once again, there's no reliability issue with the system. There hasn't been. The company has made the point that front office transactions satisfy the needs for reliability. If that hasn't been, if that wasn't what the company told the commission and other regulatory commissions for many years, I suppose I might have a different position. But that has been the position presented to this commission and other commissions for a very long time.
And if the company had taken your approach and decided to fill the capacity shortfall identified in the IRP with front office transactions rather than a wind resource, that would have been inconsistent with the recommendations in the IRP and the for portfolio, right?
It would have been inconsistent with the finding in the IRP. I grant you that, but I don't even think that the IRP truly has any significant discussion of the resource that we're talking about that's now located in Montana. We perhaps, if you could just do a search using Control F and search for Prior Mountain, I think you'll find there's a single reference to Prior Mountain in the entirety of this IRP report. And as far as I understand, the only consideration was a discussion of Wyoming wind, and I heard the discussion with Dr. Zenger this morning about the location Montana versus Wyoming, but there was no true effort to really inform parties. I don't know why. That's not been the way that Pacific Corp has acted in the past. There's been discussion on resources that the utility would acquire, and the company was looking at this since 2008. There's no reason that the company didn't bring this up as part of the 2019 IRP in a significant way. I'm not sure what the company was afraid of had it really brought it up. It could have even done an expedited proceeding to have a approval if it wanted to. It chose not to. I'm not sure why it was motivated not to. I understand some reasoning the company's given, but I'm not entirely certain why it didn't do it as it did in the past with Chehalis.
Were you at the stakeholder meeting that Dr. Zenger testified about, the May 2019 stakeholder meeting?
I was not. I do know people that were at that meeting.
Okay, well, we'll just rely on Dr. Zenger's testimony for that point. Did you listen to Mr. Link's testimony yesterday?
Yes.
Okay, and you heard him explain that his analysis demonstrated that the Prior Mountain project was a more economical alternative to purchasing those megawatts through front office transactions. Do you recall his testimony on that point?
Yes, I believe so.
Okay, and you haven't done any analysis to refute his math on that point?
Well, I accept the results that Mr. Link produced. I found that the case that I find to be significant to factor into my analysis is the low gas, zero CO2 case, and I found that not to be compelling. Furthermore, the analysis that I presented, which was, I don't recall seeing any rebuttal to, was the cost of the Prior Mountain project is significantly more expensive than any of the new wind projects. And
Mr. Hayat, sorry, Ms. Harmon's jumping in, and I missed you too. I think if you go back a little bit, we missed a few words that I think were important words.
Okay, I do apologize. I'm hearing everybody perfectly well, so I'm sorry.
If you want to start where you stated, furthermore, the analysis that I presented.
Okay. Furthermore, the analysis that I presented, which evaluated the cost of this project against alternatives, and the alternatives are those projects that are being approved in this proceeding. That is, the cost recovery is being approved in this, or is being accepted as part of this proceeding for rate recovery methodology. Those projects are significantly lower in cost, and so to suggest that the customer should pay for a project because maybe 1 penny beneficial compared to the IRP analysis doesn't consider the possibility that there could be other projects out there that are even less expensive. And we won't know that without conducting a competitive solicitation of the type that the company is conducting right now. It's in the middle of solicitation.
You cut out there again.
Sorry, Ms. Harmon, you go ahead.
Could I attempt to move my location? I'm actually sitting in the best place I could possibly sit. Does it help if I talk slower or?
Not really, I think it.
Could I go to a telephone?
Yeah, maybe calling into a phone connection is the best solution. I don't think it's the speed of your voice. It's just your internet connection seems to be a little bit intermittent.
Okay, I'd be happy to call the phone number. Bear with me, I apologize.
And just be sure to mute your microphone once you're on the phone so we don't get feedback from them working against each other.
Can you hear me on the phone?
I can hear you.
Can you hear me?
Yes.
Yeah.
Okay. So I think I have you on my phone and I should be on the screen, but I guess I'm not showing up on the screen very well. But I can fix that. Okay. I think I fixed it. Tell me if you can see me on the screen.
I think you have. I think we're in luck.
Okay. Do we need to repeat anything or?
Is it too much inconvenience just to go back to the last question that Ms. Sherman asked and start over with that question? I know we were quite a ways into his answer.
I'd be happy to. I hope I give the same answer.
I don't even remember what the question was, to be honest.
I might not need to be reminded of that too.
I can find a question for you. If you give me a minute. I believe it was referring to Mr. Link's testimony. The question was, okay, and you haven't done any analysis to refute his math on that point?
Sorry. I believe I said no. I did not refute his point on that, his math. However, I believe what I also talked about was the fact that that wasn't the only consideration. First of all,
to present the result, and I think even in his rebuttal testimony, I recall Mr. Link saying something to the effect that a project should go forward even if it has a small net benefit, which under at least one of the natural gas CO2 scenarios, it has a very small benefit. In fact, it's even negative. The point I would make is that doesn't consider the potential that there could be other projects that are least cost. A competitive solicitation process gets to that, and the company right now is conducting the competition, and they'll have the very information that would answer this question. So the company has really provided no information to prove that the acquisition of the most important components of a wind turbine was done at the lower of cost or market, and the only information presented is basically what I showed.
Okay, so there's a couple of issues in that response that I want to address. Hopefully I'll remember each of them. Are you familiar with the concept under the statute that a company can pursue a time-limited opportunity outside of the solicitation process?
Yes, they can.
And that's true even for significant energy resources, right?
Yes, they can. However, they do that realizing that it results in a higher burden of proof on their part. They really need to prove out that this resource is necessary and that this resource will lead to least cost. And I just don't think that they've done that.
So you mentioned that the company has a higher burden of proof. Is that found in the statute?
That's what I would suggest is required of the process.
Okay, so that's your suggestion. That's not grounded in the actual statute.
That's correct. I think that's
okay.
I think that's a very reasonable requirement that the company must present significant burden, substantial evidence to prove that it's a good resource.
For purposes of the rate proceeding in the statute we're under, though, we're subject to the prudence review set forth in the statute, right?
Yes.
Okay, you mentioned that the company is doing a solicitation process for new wind projects currently. Those wind projects that'll be part of that RFP, they are not eligible for 100% of the production tax credits. Is that your understanding?
Yes, as the production tax credits stand right now, they're not. But as we know, that the projects become more efficient and larger, and that leads to price savings. And we have all seen significant drops in renewable resource costs over time.
Well, the company is analyzing those products, assuming that they're going to be subject to the phase down on production tax credits, and Prairie Mountain, on the other hand, will be 100% eligible for 100% of the production tax credits, right?
Yes, and like I say, they're also considering the fact that what's going on with prices in the market and things like renewable resources. All types of renewable resources are dropping in price. I encounter that across the country, and every case I'm in, I'm told we are told about the significant drops in the cost of renewables and the efficiency gains and the larger sizes of the turbine blades that lead to efficiency on the wind turbines.
So, speaking of the efficiency of the wind turbines, you are comparing when you say that this project is more expensive than the other projects that are being reviewed in this rate case, you're comparing dollars per megawatt based on the nameplate capacity of those projects?
Yeah.
Okay. And there's lots, well, would you agree with me that each wind project is unique?
Well, recall that, the company looks at proxy resources, and so we tend to look at wind resources and attempt to compare them on a dollar per kW basis.
So there's reasons why one project might be more expensive than another due to, for example, whether roads need to be constructed, the proximity to transmission, things of that nature, right?
Certainly.
And you haven't done any analysis that sort of breaks out those particular factors and compares prices across projects factor by factor, have you?
No, but that's why a competitive solicitation process does do that, and that's the best way to do it. And the evidence that we do have is these are rather expensive projects, and we know that they're affiliates being purchased from the affiliate, and we know that there's other motivations of the affiliate who wants to make sure that they get a proper price, as high of a price they can possibly get for that resource. We don't know if it was a fair price.
We'll come back to that issue, but I'm talking about your comparison of project to project, the cost of those projects. You're also not taking into account any efficiencies associated with the project, either due to the particular turbines that are used or the location. I mean, you're just basing it on nameplate capacity, not the expected capacity, right?
Right, and I would expect the cost to go down in time as projects get larger and more efficient.
Okay. Then you haven't compared the net system benefits project to project, have you?
Well, I think that's what was presented in. I'm not sure I follow your question. I thought that there was a net benefit calculation performed by Mr. Link.
Correct. And he did that for all the projects, right? And so you haven't compared the net benefits across projects. You're just comparing dollar per megawatt across projects, right?
Right. And again, if a project has just take it at the lowest, if a project has $1 benefit, that was effectively the argument Mr. Link gave, that if a project has, I don't think he said $1, he said low benefits, or then a project is good and it should go forward. I disagree that that's the automatic go forward process. And that's basically all that we have here, is a situation where the company presents this project has net benefits, they're small in certain cases, but they've not compared it to other alternatives. They've not conducted a evaluation comparing it to other resources that the company's already acquired that are getting that are part of this proceeding, and they didn't do it through a competitive solicitation, which is ongoing. Ratepayers could find that they'd have a bigger benefit waiting and accepting front office transactions for the small amount of megawatts for a short period of time, and acquiring the resources in the competitive solicitation.
So you mentioned the competitive solicitation that's happening now. You have, given the timeline that you're aware of for the Pryor Mountain project, it wasn't feasible to include that project in the RFP process that's happening now, was it?
Well, it maybe it didn't have to be included at all.
Well, and isn't that what Mr. Link's analysis looked at? The comparison of not going forward with the project versus going forward with the project?
In a comparison of proxy resources, Mr. Link showed that this resource is lower than the cost of the proxy resources that'll fill out the system through time. In a comparison, but a utility never makes an investment decision generally strictly, and I want to clarify that they don't generally, because we know that's the case here in Utah and elsewhere. They generally don't make an investment decision strictly on the basis of type analysis. They go through to the next step and conduct a competitive solicitation to find the actual resources that they typically want to add for their system.
Okay, so I want to ask a question about a couple of questions about the turbine. You
Ms. Sherman?
mentioned yes.
This might be a good time for a short break. Why don't we take a quick recess and then return to your questions, starting with this topic?
Okay, thank you.
few questions. And Mr. Hayes, thank you for changing your connection. I think that has taken care of the issues that we were having.
Very good. Thank you.
I do see your face twice, though. That's kind of, I don't know what happened there, but that's fine. We'll go with it.
Oh, you have my face twice?
You're signed in twice, Mr. Hayes. I only emphasize that because I did it yesterday and it created tons of feedback for me. And it was only by the good nature of Chair LeVar that he straightened me out on that. So if it's causing you problems, I'd delete one. Thank you.
I did. Thank you very much for telling me.
No problem. Okay. I think we were going to talk about the turbine equipment for the Prior Mountain project. I just want to confirm a few hopefully basic points on that. You don't dispute that the acquisition of turbines from the Berkshire Hathaway affiliate has allowed the project to qualify for 100% of the production tax credits, do you?
No.
Okay, and you acknowledge that under the applicable IRS guidelines, if the company had purchased all the turbines from an unrelated party for the project, it would not qualify for production tax credit eligibility, right?
Yeah.
Okay. Did you listen to Mr. Van Engelenhoven's testimony about the benefits associated with the additional benefits associated with those turbines, including the proximity to the job site and the fact that they were in storage close by and could be transported to the site?
Yeah, I heard a lot of testimony, but yeah, yes.
Okay. And do you also recall Mr. Van Engelenhoven testified that the company did a follow-on competitive bid for, or did a competitive bid for follow-on turbines for the project?
Yes, I believe I heard him say that.
Okay, and if you believe he testified that the price for the follow-on turbines were comparable to the price paid for the Berkshire Hathaway components and turbines, do you recall that?
I'm subject to check. I can't remember everything said, but subject to check.
Okay, so the fact that the company was able to acquire those turbines from a close by source, deliver them to the project constructed in time to qualify for full production tax credit eligibility seems like a prudent use of that equipment, doesn't it?
Would you repeat that? I'm sorry.
Yeah, it really
I
wasn't.
heard you. It wasn't a connection issue. I just wanted to
It
have
was
a
my
question.
own inarticulateness. Yeah, okay. It's the fact that the company was able to procure the turbines from Berkshire Hathaway that were in close proximity to the site and be able to deploy them in a way that secured 100% production tax credit eligibility for the project seems like a reasonable use of those turbines, does it not?
I'm not criticizing the use of those turbines per se. It's the pricing of the turbines and the fact that there's no real evidence that was that the company was able to file with any testimony that really proved that those turbines are lower of cost than market.
Okay, I want to ask about Mr. Link's analysis and your concerns with that analysis. You understand that the analysis that Mr. Link performed of the Prior Mountain project was the same analysis that he's used to analyze the EV 2020 project?
Yes, I do.
Okay, and you, sorry, I didn't mean to cut you off. Did you?
Well, I think you have more of a question to ask, so I'll wait for your.
Okay, and you understand that he analyzed the Prairie Mountain project using the medium gas, medium carbon scenario and the low gas, no carbon scenario?
Yeah.
Okay, and you would acknowledge that it would be prudent for a utility to consider a range of possible future scenarios in determining whether to pursue a project?
Yes, but I think I heard you say, and you'll correct me, but I think I heard you say in evaluating the EV 2020 projects, is that what you did?
I was asking that the first question was if you understood that Mr. Link's analysis here for Prairie Mountain is the same type of analysis he did for the EV 2020 project.
Right, and that's why I sort of raised that is because, as you recall, or may recall, the E2020 projects were evaluated against each other. So Ebola and TB Flats and so forth were evaluated using a similar process. Here we have more of the RP evaluation using similar tools. So there is a difference in the evaluation in that an IRP style evaluation is proxy resources. And this is a proxy resource evaluation. But when you get to a competitive solicitation, such as the EV 2020, you were comparing the actual bids. That was the data that you had. And so that's why I suggest that a utility usually goes through an IRP process. And once it determines the type and timing of resources, the next step is do a competitive solicitation. That's what you typically base your resource acquisition decision on.
Right, and when the commission reviewed the EV 2020, it looked at the present value revenue requirement differential for each of the projects, and that's the same calculation Mr. Link has performed with respect to Prairie Mountain, right?
Well, I can't say right because my whole caveat.
Okay. This commission in 20 docket, or in the repowering docket that went alongside that, it acknowledged that the purpose of the sensitivity modeling is to consider a range of possible future scenarios, right?
No.
And that's even acknowledging that not all those scenarios are likely to occur, right?
Yeah.
Okay. And am I understanding?
Would you repeat that? I'm sorry. Repeat that question. I'd like to hear that again.
Sure. My question was, the commission acknowledged that the purpose of the sensitivity modeling that we're discussing is to consider a broad range of possible future scenarios, even if we recognize that all those scenarios may not be equally likely to occur.
I'm not sure about the last point. Is there something to on referring? There's a whole commentary that could be made on whether or not one believes that a certain scenario is more likely than the next. I'm not sure.
I do have something I can share on my screen. It would be, one second. So I'm going to pull up this would be the order on the EV 2020 pre-approval docket 17-03540. And I think what I was referring to, I'll just scroll down to page 22. Well, first, let me ask this pretty quick question. You recall in that docket that certain of the interveners argued that it would be more reasonable to rely on the low price scenario in the analysis that Mr. Link performed?
Yes, I have it was a few years ago, but I have a recollection of that.
Okay, and the commission's discussion of that is down here towards the bottom of page 22, where it says, we find PacifiCorp's economic analysis to be thorough and extensive. We acknowledge the results of the projections may vary significantly if the modeling inputs change or the facts that eventually materialize are materially different than forecast variables. And then the last sentence of what's highlighted there says, we recognize each of these scenarios may not be equally likely to occur, but PacifiCorp's economic model customer benefits in the vast majority of potential outcomes. So do you agree with what the commission said here?
Well, I do. I agree. And I'm sort of homing in on sentences that the decision to model 9 different potential future outcomes with respect to carbon and gas, I do agree. They may not might not be equally likely to occur. Certainly agree with that. And it also says that PacifiCorp's modeling shows net benefits in the vast majority of potential outcomes. We don't have results showing that there are benefits in the vast majority of the outcomes. In the low gas, zero CO2 case, we have 2 results, and one of them shows that it'll cost ratepayers money. The other case shows fairly low benefits. So we don't have the vast majority of potential outcomes showing that Prior Mountain will be economic. I might also draw your attention to the 39 docket with regard to what the commission had to say about the Leaning Juniper project. And in that, the commission recognized that the low gas, zero CO2 case, while it did not intend to give greater weight to that case necessarily, it was one of the factors that it considered in reaching a decision not to approve at that time Leaning Juniper.
Present value revenue requirement differentials for Leaning Juniper compared to, at least at the time it was presented in this docket, which I'm sharing my screen to pull up here, how the present value revenue requirements for Leaning Juniper at that time compared to the Prior Mountain present value revenue requirement differentials.
I think, as I recall, I think that Leaning Juniper had negative present values, just like there's at least one case in this proceeding with Prior Mountain that has negative as well. And there's another case in which it's low.
Okay, my recollection was that Leaning Juniper at that time, I'm trying to scroll down and find it, had resulted in net system costs in most of the scenarios, and at best had a break even. That's pretty different than what we've seen for Prior Mountain, right?
Well, I don't know if that's 100% true, because I think more cases were run at that time. Certainly, as you run more cases, you can find more positive or more negative cases just by virtue of having more cases run. In this proceeding, the company ran the medium gas CO2 and also the low gas zero CO2 cases. And at least in the low gas zero CO2, there were negative costs, just like with Leaning Juniper.
So the present value revenue requirement differential, I just want to make sure we're on the same page. That's the difference in the revenue requirements to the system for having the project versus not. So if it, say negative, a negative revenue requirement is a benefit to customers, right?
Well, that's a convention of how one might show numbers. And I do believe you're right that the convention the company shows in when it writes the testimony is that but it always explains it. It will say a negative means benefit, a positive means a cost. My typical jargon when I talk about negative benefits, I'll say when it is a cost to ratepayers, it has negative benefits. So that's how I've been using the wording. So we got to get if we're on the same page with the convention, then I think we can be in sync.
Okay. Sorry, I was just trying to pull up this. Since you mentioned Leaning Juniper, it had either a net cost of $3 million to the system, or even under the medium gas, medium CO2, it had break even. And so here, I'm going to stop sharing that for a second. If we looked at Mr. Link's analysis, the range for Prior Mountain under the medium gas scenario, medium carbon scenario, is a benefit to the system of $82 million. And worst case scenario under low gas, no carbon, is a cost of $1 million, correct?
Correct. And I don't know if you have that you could show that might be a helpful aid so that I can speak from it, because I might have some more to say about it. From what I heard, I'm not sure that I heard. I mean, I'm not sure that you misrepresented what Mr. Link showed, but my recollection of what Mr. Link shows is that the low gas 02 CO2 case, which we've been in for quite some time, and which there's no reason to believe in the near future that we're not going to be in that same situation, shows negative benefit, shows a net cost to customers.
I can pull up Mr. Link's. I don't think this page has confidential information. I was just checking. Is this what you're referring to?
Yeah. So if you look at the low gas, no CO2, which again is what we've been in for more than the past 10 years, and there's no reason to think that anytime soon that's changing. It shows you that there's effectively no benefit under one case, and there's a negative net benefit to customers. Sorry, it's a wash under one case, and a very small benefit under the other case.
Okay, so I think that was Mr. Link's point. You would agree that the LN is the most conservative model that the company forecasts, right?
Well, let's not forget, of course, that the company is doing extrapolation, and the company has this terminal value that it's including. But I don't think I'll agree with Mr. Link's terminology that it's the worst case. It certainly seems to be the case that we've had for the past 10 years, and it certainly seems to be not a case that we're changing from anytime soon.
But my question was, it's the most conservative model that the company uses, and that the commission said we need to consider a range, and the LN is the most conservative, right?
It's the most conservative in terms of having the smallest. It would result in the smallest benefits, However, it has all those other factors that I mentioned. And it's a comparison that we're making against proxy resources. It's
Okay,
not a
but
comparison.
I just want to make a follow-up question to what you just said, that under the most conservative scenario, we have a break-even scenario. Under if conditions become more favorable and we're in the MM scenario, we see a projected benefit of $82 million to the system, right?
And if the gas prices go down, we're going to see a negative net benefits. If terminal benefits never come to play, we're going to see negative net benefits. And there may be more attractive options that are available that we're not even giving the opportunity for the customers to get, because we're locking into this resource, which doesn't compare. So we simply can't compare to other options that could be. And you know, customers have to pay for this. So they have limited funds. You know, it's just because there's an opportunity, like Mr. Link said, even for small benefits, it doesn't necessarily mean that should be done.
Well, so the decision here would have been to not pursue the project, or pursue it and risk having a break-even scenario or an $82 million benefit, right?
No, pursue other projects, compare them to this project, and seek the least cost alternative for the ratepayers over the long term.
You understood Mr. Link explain the method by which those scenarios are formulated, that those are kind of derived from the IRP process and their stakeholder input in that?
Yes. It's a process. It's a process that depends on proxy resources.
And so you're not disputing the inputs that he used in formulating those models, is that correct?
No, you'd have to look at the assumptions that he used at the time that he did. The assumptions constantly change, and locking in the decision necessarily at the time that he did. I don't quarrel with the assumptions that he used, other than things like I have some concerns about the terminal value, just like UAE brings up. Though I don't really speak about it in this case. We did that in the 39 and 40 dockets. The issues that I bring up are the fact that this is a comparison to proxy resources. We don't know if this is the least cost resource for ratepayers. We do know that there is a proceeding going on right now to acquire resources, and we don't have a significant need for a 55 megawatt resource when there's significant amount of front office transactions that we're still going to have to depend on.
Okay, Mr. Chairman, if I may just have a moment, can check my notes and see if I have anything further on this topic.
Sure, we'll just hold on while you're checking that.
Okay, thank you. I don't have any further questions on this topic. I know you have another summary that you're going to prepare, so I would reserve the right to do additional cross after hearing that summary.
Thank you, Mr. Chairman. Mr. Snar, any redirect at this time?
Yes, just a little bit, if I might. Mr. Hay, you've been asked a lot of questions about the IRP process, where there's planning and possible projects by type or kind are discussed, and the various different scenarios are assumed. Let me take a page out of Justin Jeter's book. Assume you have, I'll just use 50 projects, not 100. Assume you have 50 projects, all of similar type, and you want to determine whether or not they should be built. If you do a with or without kind of analysis under a low carbon and low gas scenario, and each one produces a net benefit, would you suggest that we ought to build all 50?
No, I would not.
And how would you go about determining which one is the least cost alternative of those various different projects? Again, for our assumption, let's assume low carbon and low gas scenario, so we don't mix the different analytical factors.
Well, certainly I would attempt to do a competitive solicitation in which I would try to seek the lowest cost bids, and I would then use the company's method of using low gas, zero CO2, and all the other scenarios making up the matrix of 9 cases, and I would evaluate all those projects, but I would seek the least cost project that might be available.
And you recall Mr. Link's testimony when he was questioned about this. He said that he did a with or without comparison and found that with the pursuit of the Prior Mountain project, he saw net benefits, and so he concluded that he should proceed. Isn't that right?
Yes, and
there wasn't any further comparative analysis with other contemporaneous projects. Isn't that right?
There was not.
All right. Now, with respect to the purchase of equipment from Berkshire Hathaway, are you aware of any evidence that's been presented in this case where there's been a comparison of the price of the turbine equipment secured from competitive sources was made to the price being paid for the Berkshire Hathaway equipment?
No, I haven't seen any evidence. Raised the issue in my direct testimony about affiliates. Certainly raised it in my sort of rebuttal testimony too.
Let me just ask some clarifying questions on the issue of burden of proof. Now, counsel for the company has pointed to a statute that suggests that the question about whether or not it's a prudent decision is one that needs to be measured by the facts and circumstances at the time the decision is made. Do you recall that line of questioning?
Yes.
And for purposes of my next set of questions, I'm going to ask you to presume that we're not questioning the initial decision of prudency. But how does that relate to the possible prudency of cost overruns that are being sought for recovery in this proceeding?
Well, the company has first of all, we're not going to question the question of prudency by statute or the higher burden of proof. However, the company has the burden to present evidence in the case. And certainly there's no evidence in this case of the net benefits of the cost overruns. They have provided no support for it. And the statute actually does say, if they were to go through the normal process, the normal statute, it does say that they have to support any cost overruns. And the company is just treating it like, well, it'll just be cap ads. It'll be flow through the regulatory process the way capital additions flow through. The point they make is once we evaluated the initial cost, that's all we have to do to justify.
I have no further questions.
Thank you, Mr. Schnarr. Any recross from anyone other than Pacific Corp? Unmute yourself and let me know if you have recross any of those parties. Okay, I'm not seeing or hearing any. Ms. Sherman, do you have any recross?
No, thank you.
Okay, Commissioner Allen, do you have any questions for Mr. Hayat at this point?
I do not have any questions. Thank you. I don't have any questions. Thanks.
Thank you. Commissioner Clark.
No questions. Thank you.
Okay, I don't have any further questions. So I think at this point we were going to move into Mr. Hayet's testimony on the Lakeside plant outage. I think I can rule that the commission has already made the necessary finding previous in this hearing under Utah Code section 54.321. So with that, I think we're prepared to close the hearing to the public unless any commissioner or party has any further comment on this issue before we take that step.
I'm on the screen.
I'm not
No,
seeing.
I support closing the meeting. This is Commissioner Clark.
I agree.
Okay, thank you. We will then, pursuant to that statute, close this meeting to the public. I'll ask Ms. Pascal to discontinue the streaming and to ask everyone just to take a moment to look at the list of participants. If you see a name or a phone number that
Thank you very much.
Anything further from the Office of Consumer Services, Mr. Schnarr?
No, that will conclude our presentation. Thank you.
Okay, thank you. Mr. Russell, we'll go to you next.
Thank you. On behalf of the Utah Association of Energy Users, I call Kevin Higgins to be sworn in.
Okay, Mr. Higgins, are you with us?
Yes, I am.
Do you swear to tell the truth?
Yes, I do.
Okay, thank you. Go ahead, Mr. Russell.
Good afternoon, Mr. Higgins. Could you state and spell your name for us, please?
My name is Kevin C. Higgins, Kevin Higgins.
And could you tell us who you work for, please?
I am a principal in the consulting firm Energy Strategies.
And on whose behalf do you offer testimony in the proceeding?
I'm here on behalf of the Utah Association of Energy Users, or UAE.
In fact, you've offered testimony in both the revenue requirement portion of the general rate case docket number 20-035-04, and in the depreciation docket 18-035-36. Is that right?
That is correct.
Okay, let's go ahead and identify that testimony. In the general rate case, you've offered direct testimony identified as UAE Exhibit RR1, along with exhibits UAE Exhibit RR 1.1 through 1.18. Is that right?
That is correct.
And you've also offered rebuttal testimony, which has been labeled as UAE Exhibit RR3, correct?
That is correct.
In addition, you've also filed surrebuttal testimony identified as UAE Exhibit RR5, along with the attached exhibits UAE Exhibit RR 5.1 through 5.18, right?
Yes, sir.
Okay. And in the depreciation docket, you have filed direct, rebuttal, and surrebuttal testimony. Is that right?
Yes.
Okay. And with respect to all of that testimony in both of those proceedings, do you have any corrections to that pre-filed testimony to make today?
I do not.
Okay. And if you were asked the same questions today as were posed in that pre-filed testimony, would your answers be the same?
Yes.
Okay. At this point, Mr. Chairman, I'll move for the admission of Mr. Higgins' pre-filed testimony in both of those dockets.
Please indicate if any party has an objection to that motion. I'm not seeing or hearing any objection, so the motion's granted.
Okay, thank you. And Mr. Higgins, have you prepared a summary of your testimony for us today?
Yes, I have.
Please proceed.
Thank you. Good afternoon, commissioners and parties that are present. I offer the following conclusions and recommendations in my testimony and provide a brief summary of it. Number one, I agree with Rocky Mountain Power's acceptance of 11 specific adjustments proposed by UAE and the Office of Consumer Services as identified on lines 174 to 207 in my surrebuttal testimony. Number two, I do not oppose certain Rocky Mountain Power rebuttal adjustments as identified on lines 467 to 471 in my surrebuttal testimony. Number three, I agree with Rocky Mountain Power's acceptance of my pro forma capital additions adjustment and do not oppose the company's expansion of that adjustment to A, include new plant that is expected to be in service during the test period that was not included in plant in service in the company's direct filing. B, update the costs of its new wind projects coming into service. And C, remove the delayed plant associated with phase 2 of the TB Flats and Prior Mountain wind projects. Number four, I recommend that the Commission reject Rocky Mountain Power's proposal to calculate the revenue requirement for the delayed portions of the TB Flats and Prior Mountain wind plants using a full year's worth of costs rather than the costs that reflect their expected service during only part of the test period. Under the company's proposal, the effective test period for the delayed facilities is July 1st, 2021 through June 30th, 2022, whereas the test period for all other aspects of the case is January 1st, 2021 through December 31st, 2021. In essence, Rocky Mountain Power is superimposing a second single-issue test period on top of the test period otherwise being used in this case. The company's proposal is inconsistent with this commission's long-standing practice for treating plant that is in service for only part of a fully projected test period on an average of period basis. I also believe it may be inconsistent with the requirement that a fully projected test period may not include costs that are expected to be incurred more than 20 months after the date of application. Number 5, I recommend that the delayed portion of the TB Flats project be included in rate base at its average of period value, reflecting an expected in-service date of June 2021 with comparable pro rata treatment for expenses and benefits. This approach is consistent with conventional rate-making practice and is what would have been expected had the original schedules for these facilities anticipated a mid-2021 in-service date. The fact that these facilities are delayed from their original in-service dates should not convey an advantage to the company in terms of rate-making treatment, that is, annualization, that otherwise would not have been warranted had the original in-service dates for a portion of the projects been mid-2021. Number 6, I recommend that Rocky Mountain Power be paid $26 per megawatt hour for each megawatt hour that the prior mountain project produces for 20 years, and that the PTCs and REC revenues be retained by the company. The delay in the prior mountain schedule does not change my recommendation. The pricing I recommend is consistent with the 20-year levelized avoided cost pricing that Rocky Mountain Power was calculating for Wyoming wind qualifying facilities, or QFs, at the time the company acquired and developed the prior mountain project. I make this recommendation because the cost of this company-developed project has turned out to be considerably more expensive than the avoided cost pricing that Rocky Mountain Power was calculating for Wyoming wind QFs at the time this project was developed. I used Wyoming QF pricing because that is the Pacific Court jurisdiction that is most relevant for this project. And Rocky Mountain Power has long represented that its avoided cost pricing is intended to represent customer indifference between resources provided by QFs and comparable resources the company is planning to develop. And I note that the Wyoming Commission has authorized the use of the avoided cost method known as the PDDRR method, a method that is familiar to this commission, in a manner that is very similar to how it is used in Utah. I encourage the Commission to look carefully at the timeline of this project. In his direct testimony, Mr. Van Engelenhoven indicates that the process of acquiring and developing this project began in October 2018. Please consider this fact in the context of my confidential direct testimony, starting at line 869. Mr. Link indicates that the parties seeking to develop the QF projects at the prior mountain site did not accept Rocky Mountain Power's avoided cost calculation. He concludes that therefore the project could not be developed at the avoided cost Rocky Mountain Power calculated. But apparently the developers did not just walk away, they sold the development rights. So we don't know for sure that the project could not be developed at the avoided cost Rocky Mountain Power provided. What we know is that the developer preferred to sell the development rights rather than develop it at the avoided cost rate. Mr. Link does not address the question as to whether any other Wyoming wind QFs elected to sign contracts to develop projects at a similar avoided cost. Further, once Rocky Mountain Power starts to consider development of a project such as this, should it not become the avoidable resource for QF pricing? Yet there is no evidence that Rocky Mountain Power updated its Wyoming QF avoided costs in late 2018 or early 2019 to reflect the company's higher cost to develop Pryor Mountain and offer that price to Wyoming QFs. In fact, the opposite occurred. During this very time frame, in November 2019, Rocky Mountain Power filed an application with the Wyoming Commission to limit standard QF contracts to just 7 years. The $26 per megawatt hour avoided cost rate I am using as a benchmark in this case was the product of discovery in that case concerning the QF pricing that Rocky Mountain Power was making available to Wyoming wind QFs at that time. From a customer perspective, the high cost of Rocky Mountain Power's fast-track development of Pryor Mountain compared to the contemporaneous QF pricing for wind projects is troubling. In generic QF cases, Rocky Mountain Power has steadfastly maintained that it could provide customers lower cost and lower risk wind-generated power by developing company-owned wind projects rather than purchasing wind-generated power from QFs. The Commission should hold the company accountable to this claim and should not authorize a revenue requirement for the Pryor Mountain project that exceeds the avoided cost the company was providing to Wyoming QFs at the time the company initiated its acquisition of this project. Number 7, the accumulated depreciation reserve associated with the 11 repowered wind projects approved by the Commission, plus Leading Juniper, should be adjusted to reflect the depreciation expense associated with the retired assets that the customers have continued to pay in rates between the time each of the wind assets was retired and January 1st, 2021. This is the same recommendation I am making in the depreciation docket. Each of these repowered wind projects had a substantial portion of original equipment retired when the wind plants were repowered. The question I explore in my testimony is, what is the appropriate measurement of the retired asset value upon which Rocky Mountain Power will earn a return in the test period? Since customers continue to pay the depreciation expense associated with the repowered wind project's retired assets in rates, even after the assets are retired, one might expect that the rate base associated with the retired assets would continue to decline at the rate at which depreciation expense is currently recovered in rates for those same assets. However, that is not the case if the company's proposed depreciation treatment is adopted. Rocky Mountain Power proposes to effectively freeze the value of the retired assets on the date each set of wind assets is retired, even though customers continue to pay for the depreciation expense associated with these assets and rates. The de facto asset values remain frozen until the rate effective date of this rate case, at which time they begin to depreciate again upon adoption of the new depreciation rates approved in the depreciation docket. The problem with the company's treatment is that it deprives customers of the benefit that would otherwise come from reducing the rate base associated with the retired assets between the time of retirement and the effective date of new rates in this case. By effectively freezing the value of the retired assets at their respective retirement dates, the company is able to temporarily collect the depreciation expense on these assets that customers currently pay in rates without crediting the dollars collected against the value of retired assets. In my view, this treatment unreasonably overstates the rate base associated with the retired assets on the rate effective date of this case. Rocky Mountain Power witness Mr. McDougall contends that my recommendation is not correct because I am not considering the new capital placed in service subsequent to the retirement. However, I am fully cognizant of the new repowered plant being placed into service. In fact, I interpret the company's approach to this issue as one in which the company is attempting to obtain cost recovery for a portion of its new repowered plant prior to the rate effective date of this case. It is, in effect, a workaround of the regulatory lag that would otherwise apply to plant that comes into service prior to the effective date of a rate case. The company is basically swapping the revenues paid by customers that had been applied to recovering the cost of the now retired assets for recovery of the new repowered assets. My objection to the company's preferred approach is not single issue rate making. Rather, I am simply trying to ensure that customers are not deprived of getting proper credit for paying off a portion of the retired assets prior to the rate effective date in this case. Number 8, the retired wind assets should be depreciated over the expected lives of the newly repowered assets, as proposed by Rocky Mountain Power, which is approximately 30 years. My recommendation matches the Commission's determination in the repowering docket that the appropriate time frame for evaluating the benefits of is 30 years, the 30-year useful life of the repowering projects. Shortening the depreciable life 10 years, as proposed by the division, would add approximately $13 million to the annual Utah revenue requirement in this case, and would not improve intergenerational equity, as I explained in my rebuttal testimony. Importantly, the division failed to consider the benefits that today's customers are conveying to customers 20 to 30 years from now by paying for the newly repowered assets in rates, which will make it possible for customers 20 to 30 years from now to continue to take service from these assets, which otherwise would have been at the end of their useful lives. Importantly as well, the Commission cannot rely upon the division's representation on line 59 of Mr. Smith's rebuttal testimony that its faster depreciation schedule will provide $108 million in net present value benefits to customers, because the exhibit supporting that calculation contains a critical error in that it does not capture the net present value of the large savings to customers over the next 10 years of paying a lower depreciation expense under a 30-year depreciable life versus 10 years. In short, the division ignores the time value of money associated with these customer savings. Had the division taken this into account, the large net present value the division claims for its proposal would essentially go away. The division's proposal to shorten the depreciable life of the retired assets should be rejected. Number 9, Rocky Mountain Power's request to include its prepaid pension and post-retirement welfare assets in rate base should be rejected. Including these items in rate base would add more than $10 million per year to the Utah revenue requirement at the company's proposed return on equity. As I explained in my direct testimony, the company's prepaid pension asset has been growing, caused largely by negative pension accounting costs, which can occur due to robust expected returns on plan assets. This can cause the prepaid pension asset to increase even when company contributions to the plan are zero. If the prepaid pension asset is included in rate base, customers would be required to pay the company a return on the growth in the asset due to the expected returns in the market. I believe this is unreasonable. The issue at the heart of the company's proposal is one of timing differences. Specifically, what happens during periods in which cumulative contributions exceed cumulative accounting cost. Utah rate-making practice provides for the recovery of prudently incurred pension costs calculated in accordance with pension accounting standards. Over the life of the pension plan, the cumulative accounting cost will equal the total of the company's contributions. So the issue is not whether Utah ratepayers fully fund Utah's share of pension costs. Indeed, Utah customers fully fund the costs. Rather, the issue is who should bear the risk of timing differences with respect to the relationship between cumulative contributions and cumulative expense, the company or customers. I believe the responsibility to manage the timing differences appropriately rests with the company, and so should the risk. In Utah, utility management is expected to cope with normal business risks and the operation of economic forces. The Commission should not allow Rocky Mountain Power to shift this burden to customers. In the alternative, if the Commission approves the company's request to include these prepaid pension assets in rate base, the allowed return on the prepaid pension and PRW assets should be set at the company's expected return on assets for these plans without a tax gross-up. And finally, on this point, UAE does not support the company's alternative proposal for a pension and PRW cost balancing account, as it is an example of unwarranted single-issue rate making. Number 10. Rocky Mountain Power's proposal to recover the cost of construction work in progress and obsolete materials and supplies associated with its retiring Choya Unit 4 plant should be rejected, as these expenditures did not result in plant that was used and useful. Number 11, the share of the company's annual incentive plan expense that is related to company financial performance should be funded by shareholders, not customers, consistent with the long-standing rate-making practices of the Commission. I will note that contrary to the company's representations earlier in this hearing, the Commission's August 11, 2008 order in docket number 07-035-93 did not overturn this long-standing practice, as the evidence presented in that case by Rocky Mountain Power indicated that none of the incentives pay for which the company sought recovery was tied to financial goals. And it is clear from the Commission's order that the Commission relied on that evidence in reaching its decision in that case. Number 12, Rocky Mountain Power's projected 2021 pension settlement loss should be amortized over 20 years rather than being included in its entirety in test period pension costs. This adjustment reduces the Utah revenue requirement by about $3.3 million relative to the company's rebuttal filing. Number 13, the authorized rate of return on common equity applicable to the undepreciated balance of the retired plant associated with the company's wind repowering projects should be reduced by 200 basis points to better balance the benefits from these projects between customers and the company. In the repowering docket, I noted that the significant disparity between the benefits to the company from its expected earnings on its investment in the repowered wind projects compared to the projected benefits to customers. To mitigate this disparity, I recommended a reduction of 200 basis points to the authorized rate of return on common equity applied to the undepreciated balance of the plant the company would retire to install the repowering investment. Although the Commission granted pre-approval to 11 of the 12 repowering projects proposed by the company, the Commission reserved the question of the appropriate return on the retired assets for this general rate case. So to ensure that the company and customers are reasonably sharing the risks and benefits of the repowered projects, I continue to recommend that a reduction of 200 basis points be applied to the authorized rate of return on common equity applied to the undepreciated balance of the plant, which I note is no longer used and useful. The adjustment I recommend is intended to better balance upfront the potential benefits from these projects for both customers and the company. Number 14, Rocky Mountain Power should be allowed to recover the cost of the Craig II selective catalytic reduction investment in rates, but should earn less than a full return on rate base for this project. Specifically, I recommend that the ROE for this project be set equal to the cost of long-term debt plus a tax gross-up. Admittedly, this is a challenging issue to resolve equitably. I believe the company acted in customers' best interests by independently evaluating the economics of the SCR investment and voting no on the decision to move forward with the investment. I believe the stand that the company took on this matter is commendable. On the other hand, the fact remains that Utah customers are being asked to pay for an investment that was not cost-effective and therefore not prudent at the time it was made. In my recommendation, I've tried to strike a reasonable balance between the interests of customers and shareholders on this matter. Number 15, Rocky Mountain Power's proposal to use deferred tax benefits to offset approximately $6.8 million in projected Deer Creek Mine recovery royalties should be rejected, as these royalty amounts are not known and measurable at this time. Instead, I recommend that customers be credited with these funds plus carrying charges through the Schedule 197 in proportion to the 2-year payout proposed by Rocky Mountain Power in its rate mitigation proposal. And finally, number 16, Rocky Mountain Power's proposal to include variations in PTC benefits in the EBA should be rejected, as it unduly shifts a greater share of the risk of wind generation variability to customers. Customers already absorb 100% of the risk associated with wind generation variability in the determination of net power costs. That concludes my summary.
Thank you for that, Mr. Higgins. And before I turn Mr. Higgins over for cross-examination, I have a couple of questions to address one matter that came up during the hearing. Mr. Higgins, were you listening to the hearing during the examination of company witness Julie Lewis?
Yes, I was.
And did you hear Ms. Lewis make reference to a general rate case ruling from this commission in 2008 regarding the company's annual incentive plan?
Yes, I did.
Pardon me for just a second. There seems to be some sort of commotion outside my window. Trying to pick it up. Can you tell me what you understand Ms. Lewis to have said with respect to that ruling as it relates to the annual incentive plan?
The impression I got from Ms. Lewis's testimony was that she was suggesting that the Commission's 2008 order in the docket I referenced in my summary had allowed for recovery of the same kind of financial incentive costs that the company is seeking to recover in this case, in which I am recommending be disallowed.
Did Ms. Lewis make reference to that ruling in her rebuttal testimony?
She did not.
And as a result, did you have an opportunity to respond to it in your pre-filed rebuttal?
I did not.
Okay. After hearing Ms. Lewis's statement about that ruling, have you had a chance to go back and look at it?
Yes, I have.
And what can you tell us about what the commission ruled with respect to the company's AIP plan and its inclusion or incentives for financial goals?
Well, the Commission's decision, this discussion of that topic and its order occurs on page 61 and 62 of its order in that case. And in that order, the Commission reaches the conclusion that there is no evidence that the company is seeking to recover costs related to financial incentives. And based on that finding, the Commission approved the company's annual incentive plan expense. But there was no discussion of overturning or its prior rulings on disallowing financial incentives, and no recognition or acceptance that, in fact, the annual incentive plan that was under consideration in that case included financial incentives. In fact, the very opposite was the case. The company had provided a sworn testimony in that case that its annual incentive plan for which it sought rate recovery did not include financial incentives.
And just to put a point on that, I'd like to address your attention to that report and order dated August 11, 2008. I circulated those to council and to the commission a short time ago via email. I'm going to share my screen just, I think, to make this go a little bit faster. That's my hope anyway. We'll find out. And does that document show up on your screen, Mr. Higgins?
No.
Okay. Let me try that again. Oh. How about now?
Yes, it's coming. It's showing up.
Okay, great. So this is the report and order dated August 11, 2008 from docket number 07-035-93, which I've marked as UAE Hearing Exhibit 1. I'm going to skip to its PDF page 66, but it's page 62 of the ruling. And I'll scroll down to, there's two parts that I've highlighted just to kind of make this point. Did the company address two different incentive plans, one for management and one for, I guess, non-management in this docket?
Well, there was a discussion of the fact that there were two different plans, and the plan for management, which included financial incentives, was not included as in the revenue requirement being requested by the company in that case. And there was a plan for other employees, which was the basis of the annual incentive plan expense that the company sought recovery of in that case.
And that's shown in these two sentences that are highlighted here on page 62. And probably for the record, it would make sense to read them in, and I'll do that. I've highlighted the last sentence of the penultimate paragraph on page 62, which states, the company indicates there is a separate plan for company executives based upon financial results, and the expenses associated with that plan are not included in the company's filing. Do you see that?
Yes, I do.
Okay, and so that suggests that the commission or that the company did not include those portions of its incentive plan for executives that provided an incentive for financial results, right?
Yes.
Okay, and then at the bottom of the next paragraph, the last two sentences on this page, it states, this is the commission states, we conclude the elements of the incentive compensation program for which the company seeks recovery from ratepayers are not related to financial goals. Therefore, we accept the company's test period forecast for incentive pay. And is that the basis for your conclusion that the commission reached the conclusion that the incentive plan for employees did not include incentives for financial results?
Yes, that in combination with my review of the testimony that the company provided in that docket.
Okay, and let's look at that very quickly now. I also circulated that. It's marked as UAE Hearing Exhibit 2, and I'll just represent that I pulled both of these documents off of the Commission's website for this docket. And this is the rebuttal testimony of Mr. Eric D. Wilson. And I'll turn first to page 19 of that testimony. And this would go, I think, to the senior management incentive compensation that we just talked about. And the question there on line 411 states, does the company maintain any incentive pay programs that are tied to financial metrics? And the answer is yes. The company does offer a long-term incentive program to select senior management levels. This plan is based on Mid-American net income improvement and is vested over a 5-year cycle. We are not asking for recovery of costs associated with this program. Is that right?
Yes.
And that's consistent with the commission's conclusion on that point, correct?
Correct.
Okay, and then I will scroll back up to page 17, starting in the middle of line 366, where it says all of the employees' goals focus on objective outcomes that are very closely tied to safety, reliability, and customer service. None of them are tied to financial outcomes, right?
Correct.
And is that consistent with the commission's ruling on that point?
Yes.
Okay, so having reviewed that information, do you reach any conclusions about what the company sought and what the commission ordered with respect to that general rate case and how it regards incentive for financial goals?
Well, in fact, Mr. Russell, if you wouldn't mind toggling down to about line 405 of Mr. Wilson's testimony.
Sure.
We can also put that into some context. We can see right about line 405, Mr. Wilson makes the point again. At any rate, none of the incentive pay for which the company seeks recovery is tied to financial goals. So taking in context this testimony from Mr. Wilson, as well as the previous testimony from Mr. Wilson that you shared, and then examining the commission's conclusion and its orders, it's clear that the company's representation was that the annual incentive plan that it presented in the docket in question did not include incentive compensation tied to financial goals. And so therefore, when the commission accepted this incentive plan into the revenue requirement, it was in no way changing its longstanding and fully articulated policy that I had provided and cited to in my direct testimony, that financial goals are to be excluded from the revenue requirement when it comes to incentive compensation in Utah.
Okay, thank you for that. And at this point, I'll move for the admission of UAE hearing exhibits 1 and 2.
If anyone objects to that motion, please indicate your objection.
Well, this is Mr. Saban. I guess let me turn on my video here. I don't have any problem with the commission's order coming in. That's fine. But earlier I was not allowed to, or it was objected to that I was putting in testimony from another proceeding earlier, and I think the same standard should apply here. I mean, he's addressed it in the record. I think the purpose has been served, but I don't think it should be a proper exhibit if I'm not able to do as well. So.
And like Mr. Saban, I'm not offering this as UAE's witness here, and that witness isn't here to be cross-examined. It was merely for the purpose of illustrating the point. I'll offer it for that purpose.
But I don't think it comes into the record, is the point. Right.
Yeah, let me ask you this, Mr. Russell. Is that purpose already accomplished at this point without your motion?
And I will admit at this point, I don't recall whether Mr. Saban's exhibit came in or not. If it didn't, then this one can stay out. It's fine. Whatever the ruling was earlier, I agree it should be again.
Well, there was no ruling earlier because Mr. Saban simply withdrew his motion to enter into the evidence after the objection. Okay. So we didn't rule on it. But the giving it the same treatment as it had earlier would be just treating it for the purpose that it's already been used in Mr. Higgins' comments.
Yes, and that's fine. I don't need it to be an exhibit here. It's a matter of public record anyway. So.
But to be clear, Mr. Chairman, I don't have any problem with the other exhibit. That's fine.
Okay, so is there still any pending motion, Mr. Russell?
I guess the motion is for the admission of UAE Exhibit 1, which was the report in order. I don't hear Mr. Saban objecting to that one.
Okay, if there's any objection to that motion, please indicate it. I'm not seeing or hearing any, so that motion is granted.
Thank you. And Mr. Higgins is now available for cross-examination and commission questions.
Thank you. Why don't we take a 10-minute break and then we'll return and move forward with cross-examination. Thank you. And Mr. Russell, we're ready to go to cross-examination questions. Is that right?
That is correct.
Okay, I will go to Mr. Jetter first. Do you have any questions for Mr. Higgins?
I do have just a few brief questions. Good afternoon, Mr. Higgins.
Hello, Mr. Jetter.
And this is with respect to the amortization of the decommissioned wind turbine equipment. It's an accurate statement, isn't it, that the overall project to replace the decommissioned wind turbines results in two primary, benefit sets. One is the production tax credits that run for 10 years, and the other is the zero fuel cost energy production that would presumably run for 30 years if the new equipment lasts that long.
I agree.
And that's being balanced essentially against the value of decommissioning the old equipment, along with the loss of the generation from the old equipment and the cost of the new equipment. Is that a fair summary?
Well, I would add to that, Mr. Jetter, you've got the cost of paying off the retired equipment. Maybe that's what you meant by decommissioning, but essentially you have the remaining book value of that retired plant that is being paid off by current day customers, even though it's no longer in service.
Yeah, that's what I was intending to get to with that question. And is it a fair assessment that because of the relative values of the PTCs as compared to the zero fuel cost energy, that the payback is in some sense, the benefits are front loaded out of those 30 years, and that a large portion of the net present value of the benefits comes in the first 10 years?
I would agree that the PTC benefits by their nature are front loaded, and therefore there is a greater benefit from that, or that benefit occurs during the first 10 years.
Okay. And is it a fair, a fair characterization that it's ultimately somewhat of a policy decision whether you would try to match up the amortization of the decommissioned wind turbine equipment in that 10 years with the PTC, if you viewed it as matching more closely with that benefit? And it could also be potentially a policy decision to match it with the 30 years of the zero fuel cost resource.
I agree that it's a policy decision, and I just urge the commission not to adopt the policy being recommended by the division.
Okay. Those are all my questions. Thank you for your time.
Thank you.
Mr. Snar, do you have any questions for Mr. Higgins?
No, the office has no questions of Mr. Higgins.
Thank you. Mr. Holman?
I have no questions. Thank you, Chair.
Thank you. Mr. Sanger?
I have no questions. Thank you.
Mr. Boehm? Okay, Mr. Saban?
Thank you. Just a few. Good afternoon, Mr. Higgins.
Good afternoon, Mr. Saban.
I want to start where Mr. Russell left off, as it's fresh in our minds, on the annual incentive pay issue. Do I correctly understand that you agree that what we're not talking about here is any type of bonus? We're talking about normal compensation for standard employees. Is that a fair statement?
I agree that it's not considered a bonus, but the characterization, I believe, that Ms. Lewis gives to it is at-risk compensation.
Let me rephrase what I'm actually trying to get at. What Ms. Lewis testified about earlier in the week was that if you take base pay plus the incentive pay, that is market comp. That's 50 percentile of what you'd pay an employee and anybody else in the market to come in and do the same job. Do you have any reason to disagree that that's what Rocky Mountain Power has done here?
No.
So we're not talking about, and I think if you want me to point in your SIR rebuttal, I can, but leaving your SIR rebuttal, you say you agree with Ms. Lewis that we're not talking about bonuses, right?
Yes.
Okay. In your rebuttal, you cite to a case, and it's a U.S. West case that is from 1995, and it's on page. I'll just direct you to your direct testimony at page 28, if you'd like. That's where the U.S. West quote appears. And I guess my first question to you is just to ask you, that is the case you're relying on for this, quote, long-standing position of the Commission on incentive pay, right?
Yes, that is I believe that is the case that most clearly articulates the Commission's policy on it, based on my own experience and research on the question.
And your understanding is that case is still good law?
Well, I'm not an attorney, but I believe that expressed the Commission's policy, and I'm not aware of any case in which that policy was overturned.
Okay. We've sent out a copy as an exhibit of the U.S. West case, and if your counsel hasn't already sent it to you, Mr. Russell, could you send that to Mr. Higgins, please?
Yeah, I'll send it now.
This is marked as Rocky Mountain Power Cross Exhibit number 13, for those who are wondering which one I'm referring to. That's the one I'm referring to. And Mr. Higgins, if you just tell me when you get that email from Mr. Russell, that would help.
Okay, I got it.
Okay, this is the 1995 U.S. West case, and if you could go with me down, it's a long document, I apologize for that, but if you can go down to section 23, which starts on page 12 of the PDF, that's where I'm going to start, okay?
Okay.
Let me know when you're there. There should be some highlighting on that screen.
I'm there, yes.
Okay, and I'm going to pop that page up onto the screen as well. Let me just represent to you, so we can speed this questioning up, that this page is the page where the Commission starts talking about past cases dealing with incentive compensation. And let me just represent to you that I've highlighted the Commission's discussion of every single instance that it was referring to in this case, and there are 4 or 5 of them. And let me just represent that each one of them has to do with management bonuses being awarded to management level employees or executive compensation bonuses. Do you, Mr. Higgins, have any basis to dispute that the U.S. West case was discussing that issue?
I'm reviewing the doc, Mr. Saban.
That's fine. No problem.
Well, I would agree that the first highlighted section discusses management bonuses, and
I've highlighted, Mr. Higgins, each of the, in the first paragraph, they're talking about a 1984 case that dealt with where a commission disallowed a management bonus because the awards were based on financial performance, right? But that's focusing on management bonuses, right?
Correct.
And the second case here in Docket 88 that they're referring to dealt with bonuses based on financial performance for US West Inc. employees, right?
Correct. And I don't, just to be clear, I do not see that as being limited to executives or top management.
But it's dealing with bonuses, right?
The word bonus is what is used here, yes.
Okay. The next one in docket 990-035-06 dealt with where the commission had directed the division to investigate appropriate determinants of bonuses recovered in rates from ratepayers, right? And the last one, this 92-049-05, was talking about a plan consisting of stock options and job performance shares, both of which were additional compensation to executives.
Yes.
If the stock price increases in the long run, right? That's executive bonuses in the form of a stock option or shares, right?
Correct.
Okay. Now, this particular case, the US West case, it was also dealing with a proposal of US West executives to receive bonuses, is it not? And if we look down here on the two paragraphs I've highlighted, it says, the division comments that the company's survey of plans offered by other companies, many not regulated, revealed none having the regulatory handling of such bonus plans. And then, it goes on to say the division also testifies that it would take truly exceptional circumstances to justify the incentive compensation expenses of an unregulated parent being passed through a utility affiliate for recovery from utility ratepayers. Can we agree, Mr. Higgins, that what they're talking about in that US West case is nothing at all like what we're dealing with here?
I don't agree, sir. In this particular instance, US West appears to have been focused on bonuses for executives, but the commission speaks to the issue more broadly. If you look at the highlighted section that begins, the commission has previously heard and rejected the argument.
I'll go to that. I'll go to that one. I'm going to read that right now.
Okay.
Mr. Higgins, just seize on my particular question. Yes. My question was only, in that US West case, we were dealing with bonuses, weren't we?
We were dealing with bonuses. I would not put undue weight on the terminology in this discussion. I agree that we've discussed whether or not the at-risk compensation the company has, the Pacific Corp has, whether that's considered a bonus or simply part of the compensation plan that is at risk. Clearly, the term that was being used here was bonus. But of course, the thing that they have in common that I'm addressing is whether or not there is a financial linkage to whether the employee is being paid a greater amount of money based on the financial performance of the company. And I believe that characteristic extends to whether we're talking about a bonus plan or at-risk compensation. But with that caveat, I'll await your question.
Yeah, I appreciate that, and thank you. So let's turn to what we're talking about specifically in this case. So as I understand both your direct and surrebuttal testimony, you are seeking to disallow a portion of the AIP, the incentive pay, that would be payable under the company's compensation plan to kind of the standard ways for which that would qualify for it, right?
Yes.
And I do not want to, the specific percentages that you're talking about are confidential, or they're marked confidential, and unless you tell me, I don't think we need to look at the specific percentage, other than, can we agree that it is a fairly small percentage we're talking about? If you take 100%, what we're talking about is a fairly small percentage of that 100%.
Correct.
Okay. Now, you wanted to go to this paragraph, which I want to go to that too. The next paragraph in this US West case, I'll read this, and then I've got a question for you. The commission says, Commission has previously heard and rejected the argument from Pacific Core and Mountain Fuel, as well as USWC, that increased income arising from incentive compensation reduces revenue requirement. Since financial goals can be achieved at the expense of customer service, the Commission reiterates its policy that an acceptable incentive compensation plan to be recoverable in rates must have as its primary objective customer service goals, not financial goals. Did I read that correctly?
Yes, you did.
Okay. And you were here, or you listened or watched Ms. Lewis's testimony, did you not?
Yes, I did watch it.
Do you agree that she testified that the company's annual incentive pay is based upon an analysis of 6 total factors, each of which is weighted, it has some weighting applied to it, but that the AIP is paid based upon the analysis of all factors, the accumulation of all of them?
Yes, I heard her testimony.
Okay. Mr. Higgins, a moment ago, you stated that the portion that you're seeking that it's a portion you're seeking to exclude. As I read the Commission's language in the U.S. West order here that we're looking at, I do not see the Commission saying that it can pick and choose and deny portions, that it's telling you that we're going to deny any portion of incentive pay. Rather, it's saying that as long as the primary objective of the overall incentive pay is customer service goals or the achievement of customer service goals, it is not offensive to the Commission's policy. Do we agree that that's what this language says?
I agree that the language speaks for itself. And what we have in terms of the facts in this case is we have a plan that the company has. It has, for example, for 2019, that has specific percentage weightings that are available for review by the Commission. And in fact, we're part of a confidential exhibit I offered in my testimony. And so the Commission can certainly consider for itself whether it would disallow that percentage that is directly related to the achievement of financial goals consistent with its policy. And if the Commission decides that, if most of the plan is not related to financial goals, and therefore the part of the plan that relates to financial goals can be recovered from customers, then the Commission can, obviously reach that determination. I'm providing the opportunity for the Commission to, I believe, reach a determination that's consistent with its prior stated policy by being able to specifically identify the part of the plan that is related to financial goals. And as you say, it's a relatively small part of the plan, disallow the portion specifically related to financial goals.
I presume you concede then that the other portions of the incentive plan are not in your mind in any way related to financial goals, or you would have highlighted them in your testimony. Correct. Okay. So so as a final point there, you agree with me that if we were looking at if we were looking at 100% of the annual incentive pay compensation plan, can we agree that the large majority, the great majority, nearly all of the incentive pay does not have as its goal anything related to financial performance?
I agree that the large majority does not relate to financial performance. And in my recommended revenue requirement, I included the large majority of the annual incentive plan in the UAE's proposed revenue requirement.
Okay, thank you. One last question on this issue, or one last line, and we'll go on. You heard Ms. Lewis testify that the way the company's compensation plan is established is they select the median, and then the base pay and incentive comp are intended to make up that 100% of that 50%, or the median of market pay that would have to be paid to any employee or any person in the market to work in that same kind of position. I didn't artfully say that. Do you understand what I'm asking or what I'm saying?
I get the gist of it.
Okay, thanks. I'm sorry for stumbling a little bit there. that being the case, if the company completely scrapped, if it just got rid of its incentive pay altogether and said, we're not even going to judge our employees on any factors. We're just not even going to care if they, we'll care that they perform well or not, but it's not going to have any, it's true, isn't it, that they would be paying, if they wanted to pay the median for any employee and didn't have an incentive plan or didn't have any goals, that they would still be having to pay the same amount as they would under the current scenario?
Well, perhaps if that, if the company stuck with the particular metrics that you're talking about, but of course then you would be foregoing providing incentives for improving customer service and so forth, and therefore potentially causing the company some long-term problems down the road. And in fact, I'm not recommending that employees not be rewarded for the performance of the company, financial performance of the company. I just believe that it's more appropriate for the company's shareholders to pay that part of the incentive compensation.
But I think the point I'm making is a different one, which is ratepayers or customers are not made any worse off than, they're not paying any more than they would have, no matter if the company's financial performance is the best ever and everybody obtains 100% of their incentive pay. The ratepayers would not be paying anything more than what you'd have to pay a standard employee to do that same job, absent any incentive pay.
I suppose that's possible given the metrics that you've laid out.
Okay.
But I'm going to move the company's plan.
I understand. I get the world we're living in. Thank you, though. I'm going to switch topics really quickly to CHOIA. One of the issues you reference is that there is some CWIP and some M&S or materials and supplies amounts that you have suggested a disallowance on. Isn't that right?
Yes.
Okay. If I heard your summary correctly, maybe I misheard it, but I don't think you're challenging that the M&S, let's just take them in separately. The materials and supplies, as I understand your testimony, you're not arguing that that was prudently incurred cost, that the company bought the materials for a legitimate purpose to use for legitimate operations at its plants. Is that right?
Well, I'm sorry, I didn't quite hear the beginning part of your question, or maybe I didn't hear it correctly. So perhaps you could repeat it so I understand it.
I will. Thank you for letting me know. If it glitches out, let me know and I'll start over again.
I heard it audibly. I didn't quite understand it. I didn't quite hear your what you said. It wasn't technical. It was just I didn't quite hear it.
So we're talking only about materials and supplies for the moment. I'm going to break them into two categories. If I understand your rebuttal and surrebuttal, or your direct and surrebuttal testimonies correctly, I don't believe you are taking the position that the materials and supplies were not a prudently incurred cost by the company. In other words, that the company didn't legitimately go out and buy needed materials and supplies to operate its plants.
I did not take a position that that acquisition was imprudent per se. Okay. I really reached I didn't offer an opinion on the prudence of that specific action.
Okay, and is that the same? Is the same thing true of the CWIP project?
Yes.
Okay, so let's assume those the amounts for both M&S and CWIP were prudently incurred costs. Isn't it the case that the company, under normal circumstances, would be able to recover those amounts, but for the closure of CHOIA?
Well, they would have been able to recover those amounts had they been put into service on behalf of customers. Yes, assuming that they were used and useful. And yes.
I understand your point. So you're saying that in no circumstance can a prudently incurred cost be recovered in rates, even though, even where the prudent thing would be to shut down a plant simply because you didn't have time to finish it before the decision was made to close the plant?
I would say that each case should be reviewed on its merit. And in this particular circumstance, we have an entire power plant that's being shut down prior to the end of its intended life. And we have an arrangement that UAE is not objecting to, which allows the company to receive around $146 million, I believe, to basically buy down the remaining book value of this no longer used and useful plant. And in the context of that overall benefit to the company, I believe that's a benefit to the company because it removes the risk to the company of having a plant that is no longer used and useful with remaining balances on it. In the grand scheme of this arrangement, I think it is reasonable that to the extent there are some relatively small portions of that investment, which the construction work in progress and the materials and supplies that were never used represent. I think it's reasonable for customers not to have to bear that additional cost since they were never used and useful. So I think each case should be looked at on its own merit. And in the case of Choya Unit 4, I believe that in light of the significant benefits to the company of this buy down, it's reasonable for customers not to have to pick up this relatively small portion of the cost.
Can we agree that up until the time the decision was made to retire Choya Unit 4, that the company's failure to have expended adequate resources to have the materials and supplies necessary to operate those plants, that would have been imprudent for them not to have those supplies on hand to operate the plant?
Potentially. At this point, I have not heard a clear articulation from the company as to what all of these items represent. But it's possible that it would have been improved. It's possible that it would not have been. It really, depends on those materials and how much of a stockpile was required.
Have you identified in any place in your testimony, or is there any place in the record where an intervener argues that the materials and supplies purchased were not necessary for the plant's operation?
No.
Okay. So you don't actually know one way or the other whether they were needed, and the company's position is that they were needed. Given that you don't have any evidence on that point, aren't we left with just the company's position that these materials and supplies and these CWIP projects were necessary for purposes of the operation of these plants?
Yes, we have that representation, and we have the fact that they ultimately were not necessary for operation of the plant, as it turns out. I mean, yes, the company may have been anticipating that they would have been needed. I'm not questioning that the company anticipated that they would be needed, but as it turns out, they were not needed.
And you would agree, wouldn't you, that when the decision was made to retire Choya, that it was prudent for them to stop further work on projects or to stop purchasing further materials and supplies, which it did?
I agree.
Okay. All right. One more issue I'd like to talk about, and that is Prior Mountain. Just have a couple of points there I want to ask you about. First, I want to start with the QF pricing issue, your proposal to have the pricing be limited to 26, I think it's about approximately $26 a megawatt, if I'm not mistaken. Is that right?
Exactly, $26 per megawatt hour.
Okay, and the first thing I want to know is that QF pricing that you're referring to, it was intended to be based on a 20-year PPA contract, right?
Yes.
And you have not provided the commission with any type of analysis showing what that price would have been over a 30-year period, have you?
I have not, and I don't believe a 30-year PPA is appropriate, and therefore I have not.
I know. You're not going to get disagreement from me on that. I'm just wondering, the number you're talking about, the $26 per megawatt number, is not really a number that matches up with what the company has in mind with Prior Mountain, right? It's a 30-year investment in a project, and the $26 QF pricing on a 20-year PPA does not line up with that timeline. That's all I'm asking about for the moment.
I agree, and that is consistent with how QF pricing is done. QFs build projects that are expected to last 30 years, and they were offered 20-year contracts, which the company later argued should only be 7-year contracts. And so irrespective of the expected life of the facility, what I'm proposing is consistent with the way Rocky Mountain Power calculates avoided cost pricing for QFs, or at least it did when 20-year contracts were available. As you probably know, they've been reduced to 15 years now.
Okay, and in his rebuttal testimony, Mr. Link points out that the QF pricing you're referring to was based upon information from 2016 and 17. Do you have any basis to dispute that?
No, I don't. In fact, that information was information that I obtained in discovery in Wyoming, because I was part of the Wyoming QF proceeding in 2018. And it was the result of me asking the company, which had filed a case in November of 2018, seeking to shorten the terms of QF contracts. And I asked them in discovery for the company to provide me all of the QF prices that had been the avoided cost rates that the company calculated for prospective QFs, as well as QFs that had signed contracts as of the date of the company's filing in November of 2018. So it was contemporaneous with the company's QF docket in Wyoming, initiated in November 2018, and coincidentally contemporaneous with the date that Mr. Van Hegelenhaven has given as the time that the company began investigating acquiring Prior Mountain, which is October 2018.
We'll come to that, but we agree that the information used to prepare that 20-year QF pricing was information that was several years old at the time, right?
It was what the company represented as current, sir. So just to be clear, those prices were the analysis that Rocky Mountain Power was offering to Wyoming QFs around the time that the company began looking into taking over Prior Mountain. The analysis may have been based on some earlier planning, but it was still the contemporaneous QF pricing that Rocky Mountain Power was offering.
And I think you're pushing back on something I'm not really trying to, a point I'm not really trying to make, or I'm not really going after. The bigger point is this: when Mr. Link states that when it made the decision when it conducted its analysis for Prior Mountain, all of that information was updated to more current information that was then available to do the more current, to do an analysis based on more current information. Do you any reason to dispute that?
Well, I'm trying to respond without getting into confidential information, and so pardon me for sort of parsing my words carefully here.
Okay, and if we need to, you can let me know, and we can let the chair know that we can go into confidential session if we need to. But
sure. My understanding of the QF pricing that Rocky Mountain Power was providing and offering in its avoided cost analysis in Wyoming around the time that the company started looking at the Pryor Mountain project is consistent with the $26 per megawatt hour price that I've suggested be the benchmark for this project. When Rocky Mountain Power decided to take on the Pryor Mountain project, I will agree that if the company was encountering and realizing that the cost to develop such a project were more expensive than it was representing in its avoided cost pricing, I would agree that that new project should become the new displaceable resource. But I am not aware that Rocky Mountain Power made this higher avoided cost available to QUPs at that time. So it's clear that this project is more expensive than the QF rates the company was providing to parties.
I don't think you're answering my question. Let me go back to my question. The information Mr. Link used to prepare his analysis was more current and updated than the information used to calculate the QF pricing that you are referring to. He states that in his rebuttal, and you don't dispute it in your surrebuttal. Do you have any basis to dispute it today?
No, it speaks for itself that this project is more expensive, and it therefore, represents what the company had come to conclude this project would cost.
I didn't make any of those representations to say it was more expensive or any of that. Mr. Link has testified that it was over a 30-year period instead of a 20-year period, to which you've agreed that that's true, right? Yes. And you've now just agreed that the information used is different, whether higher or lower, it's different than the information used to prepare the earlier QF pricing, right?
I don't disagree with that.
Okay. So you don't have in the record any information or any analysis to show what the right price should be, even if we were to do it as a QF pricing like you're saying. We don't have that number in the record from you, right?
I disagree with that. And we can go, and I would suggest that to be able to make my point, sir, we would have to go in a confidential session.
Okay, I'll move on. Mr. Ling made the point, and you responded back in your summary on the issue of the fact that this particular project was never done. No one ever signed up to do this project at the QF pricing that is set forth in your testimony, right? The $26. Apparently nobody wanted to do this project at $26 under that QF pricing that you're referring to, right?
I actually, in my summary testimony, I made the point that we don't know that. What we do know is that the developer made the decision that it was better to sell the development rights rather than to pursue development of the project at around the kind of pricing I'm talking about. So that's the representation. It does not necessarily mean that it couldn't be developed at that price. And moreover, that Mr. Ling's representation on that point and your representation on that point doesn't address whether any other Wyoming QFs were willing to try to develop projects at that price.
Well, I'm only talking about this particular project, right? I mean, you may have, I don't think you did in your surrebuttal or your direct, any evidence that any other Wyoming QF in this contemporaneous with this has come forward and sought to do a project at that rate. At least I'm not aware of that evidence in there. Is there some evidence I'm missing?
If we go into confidential session, I could provide such evidence.
Okay. On this point, though, the developer, you agree that the developer never signed a PPA at this price?
I agree.
Okay. And that if it were more lucrative, I guess I'll just say this. As it relates to this particular project, I agree with you. We don't know what the developer was thinking. The developer's not here as a witness, but the developer clearly didn't believe that it made the choice that it really was going to just have to sell the project other than develop it. Otherwise, they could have developed it as a QF project. Isn't that true?
Right, which is also another way of making the case that perhaps the company provided the developer a QF price that really didn't reflect the cost of the company's next avoidable resource. But clearly the developer chose to sell the development rights, not develop it at $26 per megawatt hour. I agree with you on that, but that doesn't change the fact that $26 per megawatt hour was about the price the company was calculating for a big cost in Wyoming at this time, and we've not addressed whether or not any other wind QFs were willing to develop at that point.
Okay. Mr. Chair, if we could just take a minute, I'm just going to confirm I've covered everything, and I'll be right back. Is that okay?
Certainly.
Mr. Chair, I think we're done. Thank you very much. Thank you, Mr. Higgins. I appreciate your time.
Thank you, Mr. Saban.
Okay, thank you, Mr. Saban. Mr. Russell, I'm considering whether we should just start your redirect first thing in the morning, unless you have some other thoughts on it. I don't want to rush you or Mr. Sanger and his witness. I want to make sure everyone has, doesn't feel pressed for time. So that's my first inclination. But if you want to suggest something else, please go ahead.
My redirect will be very short, and I think Mr. Higgins would appreciate me not making him bring a suit to the office tomorrow. So my suggestion would be we just push through.
Why don't you go ahead with your redirect then?
Okay, I actually have a couple of questions, and the first relates to the questions that Mr. Saban had asked you relating to the CWIP and M&S at Cholla 4. Saban had asked you whether you were aware of any articulation in the record by any of the interveners about the prudence or non-prudence of the investments or decisions that had been made that placed those dollars into the CWIP bracket. Do you recall that discussion?
Yes.
Okay, and my only question to you is, are you aware of any evidence in the record other than the company's representation that those investments were prudent that would support that representation?
No.
Okay. And then I do want to ask the follow-up question regarding Prior Mountain, and this will probably require us to go into confidential session very briefly. Mr. Saban had asked you whether you were aware of any projects having been built at around this same time for a price that was approximate to the $26 per megawatt hour PPA. And then you indicated that you had such evidence, but that you would need to go into confidential session. Do you recall that?
Yes, it's not exactly what I said, Mr. Russell. I said but what I did say is I would need to go into confidential session to discuss the question as to whether or not any Wyoming QFs were willing to develop a project at that price.
Okay, thanks for that correction. And I think we need to do that just because I think that information might be relevant to the commission's decision here. And for the commission's benefit, this information is often considered confidential by the developer and not necessarily by the company. I don't know whether the company claims that it's confidential, but I think the company is required to maintain the confidentiality that developers sometimes place on this. So I don't know if there's anybody on the call that's going to be able to, or on the conference that's going to be able to answer the question about whether this is confidential.
Were there other developers?
Okay,
I don't exactly know what we're talking about, Phil. Can you, without disclosing the nature of the confidential information, tell me what you're talking about? What document are you talking about?
I'm taking the witness's lead here in response to your question that you
you're not going to be
on. So I actually don't know that information either. You had asked a question. Mr. Higgins had said, I can answer it, but I need to go into confidential session. I just want to get that information out.
I see. Okay. Mr. Chair, could you give me just a minute to consult with my client? I'm not sure what the confines of the confidentiality are here. If I could just have a moment, I'll be right back.
Well, before you do that, let me ask Mr. Higgins if you can describe at a very high level what you would be referring to in response to Mr. Russell's question.
Sure, Mr. Chairman. I am aware of documentation that the company has provided in another docket that was confidential that would allow me to answer the question. And so it's not information that is in the record in this case. It's information in my possession in another docket that is currently active. It's active. For example, it's an exhibit, a confidential exhibit in my Wyoming revenue requirement testimony in the Wyoming general rate case. I did not include it in my Utah exhibits in the interest of limiting the amount of confidential information that I was putting into the record here. But since the subject has come up, I do believe I can address this particular question if I'm based on my knowledge of this other documentation.
Okay, with that, Mr. Sabin, do you need a moment to determine if you have any objection to moving forward this way?
Can you?
Sorry, I lost you for a second, Mr. Sabin.
Can you hear us?
Now I can, yes.
Okay. Well, I would have a fundamental objection if what we're going to be talking about is evidence that's outside of this case, that's not been submitted as an attachment or reference in anybody's testimony. I think that would be improper. If that's what we're talking about, I think that should end the inquiry.
Okay, well, I'm going to go ahead and respond to that. I think we're in the realm of response to cross-examination and then redirect based on that cross-examination that seems to me to legitimately raise the issue of allowing Mr. Higgins to answer the question to the best of his knowledge.
Well, the problem I have, Mr. Chairman, with that is I have no way I don't have this information in this docket. I don't have a binder where I can even refer to cross-examine him on this information. I mean, he's stated on the record he knows something, but I don't have any way to ask him about it.
Right, and let me just clarify. I think we're talking about Mr. Higgins just speaking about his own personal knowledge and not necessarily introducing documents. Is that what's being proposed?
Yes.
And I think I'm inclined to rule that Mr. Higgins' general knowledge of this issue, based on issues that are outside of the record, has been opened through cross-examination for further evaluation.
Yeah, I understand, and if the chair is going to rule that way, that's fine. I understand. I think it limits me because he can say whatever he wants, and I have no ability to cross-examine him on that because I don't have any information to question him about it or document to redirect to recross him on. So it just puts. I mean, it makes it so we're really tied in our ability to even verify the veracity of what's being said or if it's out of context or anything like that. So I think I've stated my get it.
No, I understand the point, and I would want to clarify that if we move this direction, we would not be prejudicing your ability to make a motion to strike based on what is said or challenging it in some other way. But I think in the abstract at this point, I don't think I'm prepared to prevent Mr. Higgins from answering this question in a confidential setting. Any further input on this issue before we move forward?
None for me.
No.
We would need a finding from the commission to close the hearing to the public. So let me just turn to Commissioners Allen and Clark. Under 54.321 subsection 4, we need a finding that it is in the best interests of the public to withhold a portion of this hearing from the public. Commissioner Allen or Commissioner Clark, any objections to that path forward?
No, I'm supportive. Yeah, I don't object either. And as I understand it, the simple matter before us is that counsel asked the witness to defend the applicability of his 26 cents per kilowatt hour number And he has confidential information that would assist him in doing that. And that seems to me to be, if that's the scope of this, it seems to me to be entirely appropriate.
Okay.
And I think it's important to close the hearing so we can receive it.
Okay, thank you. Well, I think I will take those comments as the required commission finding under this statute. Before we close the hearing, let me just say, in response to Mr. Saban's objections, I think in the interest of fairness, even though Mr. Russell expressed a desire not to require Mr. Higgins to put on a suit tomorrow, I think it would be in the interest of fairness to allow you the chance to ask any recross tomorrow morning rather than having to respond on the fly right now. So I think we'll plan to move forward that way. And Mr. Higgins, if you're not dressed the same way you are now, it would be offended. With that, I'll ask Ms. Pascal to disconnect the streaming and ask everyone to take a moment to look at the participant list. Okay, so we will continue with recross for Mr. Higgins first thing tomorrow morning in the hearing. I also just want to indicate to everyone, we have discussed the suggestion from Rocky Mountain Power at the beginning of the hearing for either closing arguments or post-hearing briefs. I recognize that there are some interveners who are not participating in the revenue requirement hearing this week. However, as we've discussed it, we have an inclination at this point to allow but not require written briefs to be filed on or before Friday, December 4th. And due to the significant issues in this docket, just the length of the issues, we're inclined to have a page limit of no more than 40 pages. So we'll ask parties that are participating in this portion of the hearing to comment on that first thing in the morning, also before we go to Mr. Higgins's recross. So, but just wanted to inform all of you that is our inclination at this point. If those timeframes or that manner of proceeding causes any concerns or problems for any of you, please indicate tomorrow. Is there anything else that anyone needs to raise before we adjourn for the day? Okay, we are adjourned until 9 a.m. tomorrow morning. Thank you.
Thank you.